dear colleagues and participants of this 6th Lithuanian-Polish colloquium. Always to start our colloquium is very emotional moment because we have always our friends from Poland participating, co-organizing this event. And let me start maybe from not so joyful situation, but I will also explain why I want to start from this particular fact. So the situation that we had last year with aggression against Ukraine has demonstrated how closely we are all connected in this global world and how strongly we need to stand together in order to prevent and address the situations from happening, situations like we had last year from happening. And in this context, we even more value our partnership with Poland, who has been supporting Ukraine in the same manner or even more than Lithuania. So this cooperation is particularly important for us. And nowadays we already used to, but we still live in situations and in the world of crisis. Sanitary crisis, migratory crisis, security crisis, economic crisis. And naturally, all the crises, they are related to, or they are connected to particular challenges by its nature. So in this context, the European Union Fundamental Rights Charter, and in particular its Article 41 on the right to good administration, becomes particularly relevant. When institutions are under pressure, this right contributes to accountability of public institutions, transparency of their activities, and protection of human rights principles in taking any public official decisions. And today we can name several areas where answers could and should be sought in the interpretation of namely this right. Now, in these times of crisis, I think we face one more crisis which my colleagues, at least in my opinion, it's worse than any other crisis. And this is the crisis of values in our societies that we see even in democratic countries. In these times of turbulences, our societies, as we know, have faced increasingly with various types of restrictions. And somehow I find it very paradoxical that those restrictions that were initially aimed to protect our rights, to protect our security, to protect our freedoms, that somehow these restrictions or such a large scope of restrictions that is being practiced in the context of crisis has led to situations where sometimes we faced ourselves to have been restricted in our rights and our liberties. So something that was intended to protect us is somehow turning against ourselves and our liberties. And in my view also, this deprives our societies of our values. Now, the main problem in my view, when we think about all those restrictions, is also that our societies somehow, they get used to those restrictions. So the new restrictions, they somehow pass or sometimes little justified, but everybody takes them for granted, and they're not so questioned. They simply pass unnoticed. And this is something that I believe we really need to think, to discuss, if we really want to continue living in valued societies, which I think is very important for us as lawyers and also for our societies in general. Today's conference is devoted to a very diverse issues of public law, of administrative law, and this is the field of law that is probably the closest related to state institutions, to public institutions. And it is also a very interesting field of law because it is in a way interdisciplinary in its nature, because it trespasses the boundaries of law, of public administration, of politics. And today, in particular in the context that I've been talking about, it is very, very important because, namely, depending on how this law is implemented, in this field of law, how do we perform, this can affect or cannot affect the behavior of public institutions and can or cannot improve the results of their activities. So you might remember, my dear colleagues, that even Plato was saying that it's not so important how many people or how many persons rule. What is important, how they are prepared to rule, how they rule the societies and the states. Public law, administrative law is clearly facing many challenges today as any other field of law. And in particular, I see the challenges on how to respond to those new roles for the public organizations, for public institutions that they are facing. Clearly, there is a lot of work also to be done for academics, for the scientists, to research those challenges, to find new solutions, to provide evidences so that also the policies to address the challenges, that they would be evidence-based. And of course, academics are in the best position, are best placed to do that. Now, looking at the program of today's event, I clearly see an evidence of and celebration of partnership and leadership. And in this connection, I would really like to cordially thank our partners from Poland, our colleagues from Slovakia who are joining online, and of course, mostly I would like to thank our two leaders and very strong, very exemplary women, our Professor Dorota Lis Staranovic and our Professor Eva Devitnikovaita from Mykolas Romeris University Law School, whose commitment, nowadays there is nothing happening without commitment. This conference would not have happened without commitment of these two strong ladies, of our partners, and also leadership that brought all of us here today. I wish you interesting exchanges, but most and foremost, the inspiration to deal with problems. Sometimes it's difficult, sometimes it's unpopular to speak about the problems that we face in the public sector, and inspiration to dwell on those issues where answers are also not straightforward, where academia needs to step in and to provide different solutions, to provide different evidences, and again to contribute to the best solutions in our society. So thank you very much for coming to Lithuania, for joining this event, and for contributing to it. So productive and inspiring discussions to all of you.
I'm thankful to Dean Professor Lira Jakulevičienė for such an authentic speech, welcoming speech. And please now join me in welcoming Professor Jaroslav Dobkovsky, Dean of the Faculty of Law and Administration of Warmia and Mazury in Olsztyn. His welcoming word will be read by habilitated Dr. Edita Sokalska.
On behalf of our Dean, I would like to read some few words, which were prepared by the Dean. Ladies and gentlemen, friends, colleagues, and dear students, we meet for the sixth time to discuss some important problems of the state and law of Poland and Lithuania. Polish-Lithuanian colloquium has been steadily introduced into the scientific landscape of the Faculty of Law and Administration in Olsztyn as an important scientific event. However, the Polish-Lithuanian cooperation goes beyond the regularly organized conferences. My department hosts doctoral students within the framework of the scientific program PROM. My four doctoral students of the Mykolas Romeris University School of Law took part in full-time and part-time scientific internships in Olsztyn in 2021. In turn, three of our employees took part in a scientific internship under the guidance of Professor Ewa Dewatnikowaite. We hope this cooperation will continue. We look forward to joint scientific projects. 2 years ago, I've opened the conference in the conditions of a deep pandemic. We faced its consequences in such spheres as healthcare, law, economy, and society. We witnessed the powerlessness of the existing legal solutions. We faced the necessity of limiting constitutional rights and freedoms in the name of preserving human life and health. The experience of the pandemic has undoubtedly influenced the perception of law as well as the functions of the state in the second decade of the 21st century. Last year, I opened the conference in the conditions of the Russian war in Ukraine. We faced not only a pandemic that had dimmed for a while, but a wave of refugees from Ukraine also. Polish universities have opened their door to students and researchers who have left their country because of the war. It was a new challenge for the state and the law. We have helped Ukraine and its citizens who experienced the horror of war. Today, we live at the time of illiberal democracy, which threatens independence and independence of the courts. The constitution is not respected in the illiberal democracy. I hope that the sixth colloquium will take place in the atmosphere free of fear, anxiety, and war. I believe that we will be able to meet in Olsztyn in person and to raise a toast for cooperation, peace and prosperity of our university departments. I would like to take this opportunity and to wish a successful future for both of us. I wish you all fruitful deliberations, stimulating discussions, and interesting conclusions. And I invite you to publish in our scientific journal Studia Prawnoustrojowe, published by the Faculty of Law and Administration. I also invite all academics and doctoral students of the School of Law to publish their papers in Olsztyn. Finally, special thanks to the Dean of Mykolas Romeris University School of Law and to Professor Ewa Dewatnikowaite for organization of the 6th edition of the Polish-Lithuanian Colloquium. Many thanks to all organizers. Once again, I wish you fruitful deliberations. So we are all yes. Thank you very much for the opportunity to moderate the first panel. And there will be habilitated Dr. Marcin Dąbrowski, Dr. Gintras Siapoka, Professor Toma Birmontiene, Dr. Piotr Chybalski, Professor Laurynas Bieksia, Ilona Iwasiuskaite. Sorry for pronunciation. Well, and the first one will be, it will be habilitated Dr. Marcin Dąbrowski from our university, I mean University of Warmia and Mazury in Olsztyn. And he prepared the subject of constitutional anti-values in Lithuania and Poland.
Okay. First of all, I would like to thank you very much for invitation, for possibility to present my findings about constitutional order and constitutional axiology. It's a great honor to be here. It's a great honor and it's a great pleasure. You have beautiful place here. It's the whole, and it's really nice. So, but let's start from the beginning. Constitutions are special and specific legal acts, and it means that they have own characteristics. Inter alia, they define and describe values, which are the elements of law. Values, it means something important, something precious, something valuable, something advantageous, beneficial. Values are purposes of human rights, of human activity, and constitutional values are kind of values which are social and which are transferred from social life, social activity to the legal system, and they are kind of evaluation what is good and what is proper, and even more they show what is improper. And together, values create a system. And we call the system the axiology of the Constitution. And generally, I assume that values, constitutional values, are external to the legal system. They become and they are results of social development, and then when legislator finds that kind of value or kind of moral judgment is very important, he transfers this judgment to the legal acts, especially to the Constitution. And in normative perspective, organs of authority are supposed to protect and develop values, and they shall to support human activities which are realize the value or any particular value, and cope against acts which violates the constitutional values. And analyzing the Polish constitution and as well the Lithuanian, I found that, and I discovered that a part of typical those positive values, we can, such as democracy, such as human dignity, true justice, there are negative or pejorative values. So the Constitution provides provisions which talk about negative phenomena, which, for example, aggression, suffering, violence, or war, and those pejorative phenomena should be struggled against by authorities. So authorities are supposed to cope with these negative facts. And such anti-values or such negative values occur both in Polish and in Lithuanian constitution. So it means that we can find such a phenomenon like war, like violence, torture, inhuman treatment, discrimination or censorship in both constitutions. And so we have to change our attitude to the constitutional axiology, because on this phenomenon consists not only on positive values, but it is creation of both positive and negative values. So those negative values are just abstract concept or concept of moral or intellectual judgments, what is good and what is improper. Because some ideas, some attitudes, some behaviors, some statements, beliefs might be considered as harmful. And the occurrence of such negative phenomena, the occurrence of such a thing causes detrimental effects or causes destruction, damages, or defend, and anti-values just generates dysfunctional effects for individuals, for a state, and for a society. And so we have to ask about what's the sources of values and anti-values. And as I said, that anti-values as well as positive values are the creation of human nature, are the creation of human culture, and they exist and shaped outside of the legal system and outside of the body of laws, and they are elements of axiological order. And moral judgments and moral evaluations are part of our culture. And there are a lot of theories which talk about how, which talk about creating and evolving, about development of axiological elements. But three or few statements are significant. First of all, those positive and negative values are created outside of the law, are shaped outside of the body of law. They are creation of human nature, and the legislator finds those anti-values and values and transfer them to the legal system. And so he doesn't create the system, or he doesn't create anti-values or values, but according to his finding and allocating values and anti-values in the Constitution, it means that he shapes the axiology of the Constitution. And commonly accepted anti-values, I mean commonly, it means that the anti-values or values which are shared by a majority of the society do not automatically, or those do not automatically become constitutional. Transfer social values or anti-values to the Constitution requires activity of the legislator. He must discover and find an anti-values as very important, and then provide provision which refers to the negative value, and then establishing a legal act which talk about such a negative axiological phenomena. And the last, or maybe not the last question, but I would like to focus on situation on the problem when the legislator allocates anti-values. And generally, typical values are placed in aringas in provisions of second or first chapter. Aringas, first chapter usually in Polish and Lithuanian constitution refers to the main rules of the state, and the second chapter refers to human rights and freedom. But it's not exactly with anti-values, because generally anti-values are not allocated in aringas, in preambles. In Lithuanian constitution, we can find them in the second chapter, in the chapter which refers to the human rights and freedom, and in provisions which talk about national security, national safety, or emergency measures. In Polish constitution, okay, something. It's not right. The Lithuanian and The Polish Constitution. In the Polish Constitution, the anti-values are allocated in first chapter, few anti-values, and in the second chapter, of course, human rights and freedom, and in as well in provisions which are devoted to national safety and emergency measures. And the last question I would like to talk about is functions of anti-values. So functions means what roles place the anti-values in the legal system, in the constitution, or answer the question what for or why the lawgiver decides to allocate anti-values in the constitution. And I can indicate four main functions of anti-values. First of all, function of legitimization is displayed on two spheres. Firstly, the negative values, similar like typical values, open the body of law to the elements of natural law. So they open the legal system, the constitution, to the phenomena which are born outside of the statutory law or to the public law. It makes that constitutions are much more flexible or increase the flexibility of the constitution, its universalism and timelessness of constitutions. Because those moral judgments are creation of society, and society changes to some phenomena its attitudes, and the meaning of these elements is changed within the changing of the development or with the development of the society. And according to this, the constitution or the text of the constitution change its meaning without its formal amendment. So it makes the constitution living text. It's much more flexible. And the second area of this of functional legitimization, that values or even those axiological order created by values or anti-values is a base of the whole legal system. Because we can say that the constitution is the base of the whole statutory law of the whole legal system. But the constitution isn't suspended in vacuum. The constitution is based on those values and anti-values. So the values and the axiological order is a base of the whole legal system. The function of integration refers to human bonds. It was said today by the dean that people gather or negative values consider society about or around or against those threats. People gather together to protect themselves against anti-values or to cope with those anti-values. So it's strengthened the social bonds. The normative function, I think it is, I don't know if it is the most important, but it's quite important that it's played as well as in two spheres. It's realized in two spheres. First of all, the organs of authority are supposed to obey the provisions which refers to the negative values. And secondly, just very negative value allocated in the constitution force some attitudes of organs of authority. First of all, organs of authority are supposed to cope or protect society against phenomena which are anti-values. Second, if the authorities are supposed to struggle against occurrence of the phenomena which are anti-values. And the last function of interpretation, refers to conception and theological interpretation of law. It means that anti-values, as well as values, are kind of purposes, and they direct and show directions of interpretation of laws, especially of constitutions. So, organs of authorities are supposed to prepare law which would concern on realizing values and coping with anti-values. That's all what I would like to say. Thank you for your attention. Thank you very much for the possibility to show my presentation. Thank you.
So, thank you very much for the remarks concerning constitutional anti-values in Lithuania and Poland. We can discuss that later. And now I would like to ask to take the floor Dr. Gintras Siapoka, representing Mykolas Romeris University here in Lithuania. Lithuanian Public Law 1918-1940, from reception and novelization to original legislative. That's the subject.
Thank you. Dear colleagues, first of all, I'm glad to be here on this event. And as a law historian, I would like to present my issue about Lithuanian public law interwarrior periods. This periodization of the interwarrior period of public law in Lithuania can be based on the following periods. First, from 1982 1922, as the process of evolution of the state and law system with a reception of the law of foreign states. Second period is from 1922 to 1926. The period of democratic parliamentary republic and intensive national legislation. And last period from 1926 to 1983. We can say that this period of authoritarian system of President Smetona and attempts to codify public law. So, first period. On the 6th of February 1918, the Council of Lithuania declared the Act of Independence of Lithuania. It stated that Council of Lithuania as the sole representative of the Lithuanian nation, based on the right to national self-determination, proclaimed the restoration of the independent state of Lithuania, founded on democratic principles. The Council also declared the definitive foundation of the Lithuanian state and its relations with other countries had to be determined as soon as possible by the democratically elected constituted Seimas. But the state was yet to be established, and the development process took place in a complex, unsettled, and political reality. One of the most important obstacles of the organization of effective legislation becomes the difficult political situation of the state. Battles of independence. First World War ended on 11th of November 1980. The destiny of Lithuania depended on the efforts of the Lithuanian nation and political powers of the Lithuanian people. And of course, the peace talks. The Triple Entente left the German army in the states which had declared independence, including, of course, in Lithuania, within the former territories of the Russian Empire in order to protect them from the Bolsheviks. But this protection was not reliable. The Soviet Russia prepared for the campaign westwards. Germans retreat to avoid contact with the Red Army. Young state of Lithuania had to fight the Bolsheviks, Vermontinians, and Polish army altogether. Situation in Vilnius, where the State Council of Lithuania and the emerging government resided, was extremely complicated. The city has been administered by the occupational German authority. So the government of Lithuania was forced to move from Vilnius to Kaunas on the 2nd of January. Temporarily transferred to Kaunas, but this temporarily took as long as 20 years. The State Council and government of Lithuania had to repulse the aggression of Bolsheviks. On the other hand, the government of Lithuania established the following institutions that supposed to guarantee activities of the state: ministries, courts, post offices, customs, and representative offices in foreign countries. Legislation at various levels was issued, which terminated the functioning of administration institutions. In this laid the foundations for the organization of public administration of the state. During this period, in fact, temporary legislation had to take place. This was because the government, the Council of Lithuania, did not have a full mandate to represent the nation. The Council and the Council of Ministers had right to legislative initiative according to the Constitution of 1980 and 1990, temporary constitutions of Lithuania. The State Council of Lithuania used to draft, adopt, and issue laws, submit inquiries for ministers, organize local municipalities. On 30 April 1990, the State Council of Lithuania adopted a new edition of Framework Principles of the Temporary Constitution of the State of Lithuania. The State Council remained the principal legislator, but collegial presidium of the State Council was replaced by the sole president of the state, elected by the Council. He was authorized with the executive power, which he exercised through the Cabinet of Ministers, which was accountable to the State Council. The provisional constitutions are extremely important for the Lithuanian legal system, not only because they first established a legislative procedure, but also because the principles of the validity of the former law were laid down here. Like any other newly formed state, Lithuania was forced to recognize the former law. Article 24 of the Permanent Constitution of 1980 established the conditions for the law reception, and that was reception's principles. First of all, only those legal acts that are not in conformity with the Constitution remain in force. Second, only those laws that we enforce in Lithuania before the beginning of the First World War was. And last, a new law passed by the state of Lithuania always abolishes the validity of recipient law in force. The most important object of acceptance was the old Russian Tsar law. All of this was all the 16 volumes which were clearly outdated and incompatible with the democratic form of the Lithuanian state. The newly issued national laws announced the relationship with the relevant accepted ones by providing specific references to the norms that had been changed or abolished. In 1990, the Council of State also adopted the law of criminal code, in which is established that criminal code of Russia of 93 remains in force in Lithuania. Of course, if it does not contradict with provisional constitution of Lithuania. I would like to mention that translation this codex was in Russian, but translation was only in 1920 and unofficial. In the long run, national law reduced the importance of the accepted laws by making them of secondary with a limited proposal to cover the gaps in national legislation. The complete removal of the accepted legislation was supposed to be accomplished by inventory, evaluation, or feasibility, relevant corrections and translations into Lithuanian language. These tasks were undertaken by the government in between the fourth and fifth decades. Second period democracy and intensive national legislation. On the 5th May on 1920, Lithuania was called the Constituent Seimas. The Sejm actively took up legislation, but in novelizing and in issuing completely new public legislation. Members of Seimas passed draft laws. Laws could be drafted by at least 8 parliamentarians. The right to submit interpellation and author. At the beginning of work of Constituent Seimas, it has been decided to organize meeting of elders, which was intended to assist the presidium of the Seimas in organizing the work. Both permanent and temporary commissions played an important role while organizing the work of the Constituent Seimas. Their task was to draft laws or discuss the draft laws to be submitted to the plenary sessions. 12 permanent commissions, which were responsible for the matters of constitution, national defense, agriculture reform, finances, education, social security, foreign affairs, municipalities, trade, industry, economy, and other matters, have operated during term of office of these Seims. Up until autumn 1922, Constituent Seimas held a total 257 plenary sessions, during which some 300 legal acts like laws, supplements, and amendments and other. The laws adopted by the Constituent Seimas has impacted strongly on the further evolution of the state of Lithuania. On the 1st August 1922, the Constituent Seimas adopted the main law of the country, the Constitution of the State of Lithuania. It was the first document with the territory of the Republic of Lithuania to set forth that the state of Lithuania was independent, democratic republic with the supreme authority belonging to the nation. Later, Seimas adopted the law on agricultural reform on the 5th February and monetary reform, and later adopted the law on the Bank of Lithuania. The Constituent Seimas established the principles of Western democratic and parliamentary state, as well as freedom of faith, conscience, and expression, quality of genders and nations, integrity of person and his right to private conscience and expression. The legislation of the Seimas created a new base of sources of public law, but at the same time did not manage to stumble upon new codes of public law, such as criminal, judicial process, and order. And last period. On 12 April on 1927 was the start of presidential regime in Lithuania, when the third Seimas was dissolved without calling elections to the new Seimas. Lithuania has been ruled under the decrease of president. The moderate authoritarian regime Smetona was railing into military officers, political police, nationalists, and numerous officials. Following the Constitution signed and issued by the President Smetona on 50 May 1928, the President became the most important institution. President was no longer accountable to the Seimas. He was authorized with full power in sphere of foreign policy and became the commander-in-chief of the army. The term of office and the president was prolonged up to 7 years. Later, on the 12th May 1938, the president announced a new constitution of the Republic of Lithuania, which has further strengthened the power of the president. The president could dissolve the Seimas or the government and legislate in absence of the Seimas or the Seima session. The abandonment of democratic principles undermined further legislature, but in the Constitution of 1928, we can see positive changes for legal system. Article 54 of the Constitution established a new government institution, the State Council. This institution body was tasked with assisting the government in drafting laws, as well as in carrying out the systematization of law. The establishment of such institution was important because the aim was to gather the highest qualified lawyers, which could no longer update novelist that law, but create new national law codes. Compared the Lithuania to other Baltic states, the development of legal system was one of the biggest obstacles, which is the lack of qualified lawyers. On the other hand, we can say that establishment of such an institution was delayed. The Council of State in the codification of public law managed only one codex, prepared not in corpora, but prepare only first parts of the penal codes. As the main conclusion of this report, I would like to fact that Lithuanian public law remained dependent on the legal systems of the former states. Foreign states. The government was unable to draft all the necessary new laws, and the novelization and often contradictory public law remained in force. As an exception became maybe only constitutional, only constitutional law, which we can characterize by with original legislative. Thank you very much for your attention.
So, thank you very much for presenting the piece of Lithuanian history, history of public law. And I would like to ask to take the floor Professor Toma Birmontiene. Constitutional grants for the removal of judges from office, Lithuanian experience, it will be the subject, very interesting subject also. Concerning Polish law. Yes.
Thank you very much. First of all, I would like to thank very much Dorota and Eva, because thanks to their attempts and their energy that we are meeting every year, even it was very difficult in times of COVID, but nevertheless, I hope that at least we can see each other and we can discuss much more freely. And it is a bit. Now we understand, maybe I feel that it is a privilege when you can just discuss face by face, but not just looking to the computer, yes, and trying to, to tell what would you like to present. And I'm also it's very nice that such a cooperation between Poland and Lithuanian lawyers. We also compete somewhere, and yesterday both countries, and Lithuanian song and Polish song, went further to the finals of Eurovision. So we will compete, but I hope that this is the only field that we would like to compete. Maybe in all other fields, I hope we will be just cooperating and looking and sharing experience and helping each other. The title of my presentation, of course, is very important, and it is very important, and especially for Poland, for Polish system. But of course, it is important and for Lithuania. And I would like to stress the importance of judiciary itself. In the very beginning, and the dean of our law school stressed very much that we are really we are living in times of crisis, and we have a lot of different crises. So it was COVID, war in Ukraine, Russian aggression in Ukraine, recession, energy prices. A lot of things are coming around. So that's why we as a society, we are very often in hands of politicians. And if we look to the rule of law and to other requirements, division of powers, legislative, executive, and judiciary. So the only power, judiciary, is not based on political grounds. So in times of crises, judiciary, it has a special meaning and a special role, because this is the only power that can stop the political initiatives that are going beyond the borders, beyond the constitution. And the judiciary is the power that could survive democracy and democratic values. But of course, for judiciary to be strong enough, we need to support and we need to strengthen judiciary itself. Because without it, the political powers, they also are always playing. And in many countries we see, and Poland is not the only one, and Hungary is not so unique in Europe, but what we see, what happens in Israel, and how society supported the judiciary, the courts, the Supreme Court, and was against the changes of the whole legal environment. So I think it is very important, and it gives some hope that society will be strong. But in our countries, I think that in Eastern Europe, in Middle and in Eastern European countries, maybe our societies sometimes, though, are trying and making some attempts, and Poland is one of the examples. I do remember how many people went on the streets when the Constitutional Court was, from the 2015, had a lot of problems. It still has. But nevertheless, a lot of mechanisms have to be done before the crisis comes. Because during the crisis, when any crisis is coming, when you do not have everything in place, when you have difficult problems with the judiciary, when judiciary is not strong enough, then of course you have to face even more problems than it could be. So speaking about the guarantees of independence of the judiciary, I hope, and I know that every of us, we know it very well. We lawyers speak about a lot on this subject, and we know the decisions, and especially against Poland and from the Court of Justice and European Court of Human Rights. So we do understand that there are a lot of problems. Maybe they are not so visible in Lithuania, but to say that we do not have problems with the judiciary and we do not have problems in case of release of the judges from the office or in appointments of judges to the office, I think it will be very naive. So we also are having some problems, but our problems are a little bit different. And sometimes they are more invisible, like for instance in many other countries. But for these invisible elements, I would like, first of all, to speak about things that are making strong Lithuanian judiciary and some mechanisms, some elements that make the Lithuanian judicial system strong enough to stand maybe in the face of crisis. And first of all, a very important element of Lithuanian organization of Lithuanian judiciary, of course, it is the role of the Constitutional Court. We were really lucky that through all that time, the Constitutional Court was functioning and was adopting a very strong and sometimes very even brave decisions. And I do remember when we were meeting with the Constitutional Court judges of Poland almost every year, not almost, every year. In Poland, in Lithuania, we had a really very close cooperation and collaboration. And I do remember how the judges were asking, why are you, can you take these decisions? Why you are so interpreting? It is an activism probably. But when the crisis came, I think that our colleagues, Polish colleagues, then understood that they also had to be more active when they were in their office, when they were adopting the decisions, and probably maybe some crisis, maybe there will be made some barriers for the politicians just to manage that way that it was done with the Polish Constitutional Court. So coming to the most difficult, most different decisions that are helping Lithuanian judiciary, I would have to speak about the Judicial Council and the role of the Judicial Council in Lithuania. One of the first, so there were, of course, a lot of weddings, but one of the first decisions of the Constitutional Court was of 21st December 1999, when the Constitutional Court said that not executive power is in power in appointment of judges. And the judiciary have to be self-governed and not Ministry of Justice, but Judicial Council has to take many responsibilities, especially as under our constitution we have some delegations for the president, so president plays a very important role, but nevertheless the Judicial Council is also have to be more strong and more independent. The next decision is very important. It was of the 9th of May 2006. This is a very long decision and taking a lot of elements. But what was very essential in this decision? In this ruling, Constitutional Court said that Judicial Council has to be composed only of judges. No politicians have any seat, or no political appointees have any seat in a Judicial Council. I think this is absolutely essential. So from 2006, whether the Judicial Council was working well or when it had some problems, or maybe slow, or maybe no, maybe there were some problems, but nevertheless, the whole Judicial Council was, from that time and till now, is composed only of judges. So there are no representatives, no from the parliament, no from the government. It helps and sometimes it raises problems, because when we speak about financial side of our judiciary and salaries of judges, of course it's more difficult to be strong and to battle the politicians when we know Judicial Council for judicial self-government bodies. It's not so easy. So that's why we really have some problems, and very serious problems in financing of the courts and, of course, the salaries of judges. The next decision that is also very important and was adopted in 2022 on the 15th of April is also a very important in developing the role of the Judicial Council in Lithuania. And it looks like why we need and why that decision was adopted, why even it was not enough after 2006, why the Constitutional Court strengthening the Judicial Council even a year ago, and what was maybe the reason. So in this case, I would like to address to the situation in which the Constitutional Court appeared and found itself, when the Constitutional Court in these cases had to decide the cases about release of the judges from the office. And these were very prominent high-level judges, and of course there was a question not of the judges but of the legal acts, of the legal acts of the president, of course, whether he has the right to address the parliament on this issue, or whether the parliament can decide on that issues. So this was a problems that there were some criminal started investigations, and through these criminal investigations, judges from the Supreme Court and from the Court of Appeal, they were suspended from the office, and of course after that the proceedings are going for a long time all over, probably not only in Lithuania, and that also was a very important normal question, what to do with the dead judges. They are suspended from the office. Of course they have to be released from that office. So in this case, if that will be all judges from the lower level, maybe these things will not come out. But if we speak about the judges and the presidents of the Supreme Court and of the Court of Appeal, there are two grounds for the dismissal from the office. The impeachment, and impeachment has two grounds: the violation of the gross violation of the oath, the gross violation of the Constitution, and the breach of the oath. And we have another article, Article 115 in our Constitution, that speaks about one of the possibilities to release to release a judge from the office in case of discreditation of the office. So first of all, in this decision, and judges that were the problems that came for the Constitutional Court, the judges from Supreme Court and from Court of Appeal, they thought that we have a guarantees in the Constitution. The impeachment process is, of course, more difficult and more complicated, and Constitutional Court is involved in that case. So that is not so easy to release a judge from the office. And for a period of time, it was very clear that in case of the problems that will appear for the Constitution, for the judges of Supreme Court or Court of Appeal, maybe the impeachment process has to be started. But at the same time, we had another provisions in the constitutions, and these provisions is more easy to decide, to go through. So it's much more easy just for the president to address the parliament, address the judicial council, then go to the parliament votes, and just you do not need that level of votes like an impeachment, just of a majority. Through the majority voting, you can release a judge from the office. So in this case, the Constitutional Court was, from one point of view, tired by its previously developed doctrine, when the Constitutional Court was just not very clearly, but nevertheless not very precisely, but was speaking about that, oh yes, judges could be released if they discrediting their office, and the Constitutional Court, while forming that, the doctrine was not just saying that it is not applicable for the judges of the Supreme Court or Court of Appeal. It looked like that, no, it goes for all judiciary. So that's why for the Constitutional Court it was rather difficult, that because the discreditation of the office could be an offense, and it could go to the impeachment, and at the same time, the discreditation is also a very wide notion. So in this case, I think that in this decision of 2022, maybe the Constitutional Court had to make more clear grounds, the discreditation from the office. What is the difference then from the grounds of impeachment? Because now, if you read that decision, it looks like no difference. No, so just the president has to think about it, the parliament has to think about it, so it's a very big liberty, too wide liberty. And now, in these cases of the discreditation of office, it looks like that the Constitutional Court gave some kind of discretion to the parliament and said, no, but if the president doesn't do anything, so the parliament can jump and start these procedures. So I think that in that case, it looks like that it depends on the political powers, on their wish, but not on the grounds of the Constitution. So in this case, I think that situation of the judiciary, of the judges at the Supreme Court and the Court of Appeal, of course, they feel less secure. But if we speak about the discreditation of the office, the Constitutional Court didn't put the content in this. But at the same time, it widened it. And the Constitutional Court said that it's not only when you are in the office, but your activities out of office also could discredit your mandate. So from one point of view, it became even wider. The politicians' maneuver for the politicians is also a little bit wider. So the situation is a little bit more complicated. But in this case, the Constitutional Court then further and strengthened the powers of the Judicial Council. And the Constitutional Court said that in this case, when the question comes to the discreditation of the office, and when the question comes to the release a judge from the office, then the Judicial Council has exclusive rights to decide and exclusive right to say whether that action took place and whether the grounds exist. And I would like even quote a little bit. Neither the President of the Republic, having asked advice from the Judicial Council, nor the Parliament, same as when dealing with the removal of a judge, can re-examine the issue as to whether a judge has not committed a certain action, conduct, and if such action has discredited the judicial office. And the court says further, the President of the Republic or the Seimas could not re-examine whether certain action existed or whether it is discreditation of the office. So in this case, it is a very strong guarantee, because now judicial office plays some kind of quasi-judicial role of quasi-judicial institution. The Constitutional Court also said that in this case, the judge has a right to address or to challenge the decision of the Judicial Council even in the court, so made some kind of a guarantees. But nevertheless, I think that this is a very strong wording, a very strong guarantee, and I hope that in this case it is some kind of a strong guarantees for the judges not to be released from the office just on the notion that no, for the politicians one or another discreditation could look very maybe, or that is the discreditation of the office. So coming to the end, so this decision, this ruling of the Constitutional Court, of course, is very important. I do understand, I do feel that there was a possibility, the court had to find some kind of guarantees, of stronger guarantees, not to giving the just right for the politician to decide whether to go for the impeachment through the impeachment procedure or through the Article 115. But in this case, another question comes out, whether our Judicial Council is very strong itself, whether judges that are elected and that where they really are, they can play that role that the Constitution now puts on their shoulders. I hope we have to believe that they will be strong and they will be not just a play or just will be not influenced by populism and political games. So thank you very much.
Thank you very much, Professor Toma Birmontiene, for presenting the subject of Lithuanian experience concerning the removal of judges from the office. And now I would like to ask Dr. Piotr Chybalski, who represents the Cardinal Stefan Wišinskis University in Warsaw. He will present the subject of Polish electoral law in times of the COVID pandemic. He will present some reflections on the future. Yes.
Thank you very much. First of all, I would like to thank the hosts for granting me the honor to come here and to deliver the presentation. I must say that we have a very inspiring topics, a very interesting conference. We meet in a beautiful venue. We have a great weather outside. So the only thing that is going to be said will be my presentation, because I'm going to try to show you how not to deal with electoral law in times of emergency. But first of all, as an introduction, I would like only to briefly say that that the Polish electoral law is governed by several legal acts, as in, I think, all democratic countries. First of all, it is determined by some constitutional rules. The Constitution sets the basic principles of Polish electoral law, which are standard ones: universality, direct elections, secret ballot, and so on and so on. We have an electoral code drafted in 2011 that combines the core of statutory electoral law. We have also some EU legislation, which is obvious to you because you also have it. It governs the elections to the European Parliament, above all. We have also some bylaws, for instance, determined by the National Electoral Commission, which is a central, to some extent, judicial body governing the holding of the elections. So, what happened in 2020? The elections, the presidential elections, were about to be held simply because the term of office of President Duda was about to end in August 2020. So in February 2020, the Marshal of the Sejm, basing on its constitutional power, ordered the holding the new presidential elections. And the elections were set out, the day of vote was set to be on 10th May of 2020, the first stage of the vote. The candidates were about to be registered until 26th of March 2020, but immediately after the ordering the elections, the campaign started. So everything started as usual. But a month later, the COVID pandemic came into Poland. So we were in the middle of electoral campaign. The government introduced two measures. First of all, the state of epidemic danger, and 10 days later, the state of epidemic. Well, it is important to stress that these are two statutory measures. They are not prescribed by the Constitution. But, for instance, public assemblies were limited. So, effectively, the campaigning was suspended. So, what to do with the elections underway? As you can see, four options were considered. The first one was to do nothing, just to try to hold the elections as normally. The second option was to amend statutory law, meaning the electoral code. How to amend was another question. The third option was to adopt a special amendment to the Constitution which would allow the prolonging of the term of office of the president. The idea was to prolong it by 2 years, so move it from 5 years to 7 years. And in such case, the term of office of President Duda would end in 2022. That was the idea of one of the politicians, Mr. Gowin, who will be an important person later in my presentation. The fourth idea was to introduce one of constitutional extraordinary measures called the state of natural disaster. A worldwide pandemic seems to be a typical example of a natural disaster, and if such a measure is introduced, then the constitution prohibits holding the elections during the time of an extraordinary measure and 90 days after its conclusion. What was chosen? Well, the politicians looked at the polls, and when there is a danger, the political scientists observe an effect which is called rally around the flag. It simply means that the nation integrates with the government. The oppositional candidates cannot effectively campaign. The governing president who seeks re-election is still visible in the media because he fights pandemic. And the polls rise. He becomes the person who would likely win. So the majority who supports the president wanted to hold the elections. So what they did, they opted for some statutory changes. First of all, they amended the electoral code on 31st of March 2020, and they extended the possibility of postal voting. In Poland, postal voting is limited only to persons with disabilities and to elderly persons of having an age of at least 75 years. The age was reduced to 60 from 75, and also persons who were staying at home because of the infection in quarantine, they were allowed to vote by post. Secondly, it was another possibility was introduced to move the day of the vote, but still keeping it without the constitutionally prescribed deadline. So the vote could have been moved only from 10th May, either to the 17th May or to 24th May. That was the only thing that the Constitution allowed. A few days after this amendment, the governing party surprised the opposition. There were no negotiations, the politicians didn't talk. There were no mutual talks with the government and the opposition. And the government and the Law and Justice Party wanted to make a small surprise. On 6 April, a special statute was adopted by the Sejm, and the idea was to hold the elections at any cost. But the idea was to introduce a compulsory postal voting. So no personal voting, no proxy voting, only voting by post. What was the problem? We had, and we still have, a particular political situation within the Polish parliament. The Sejm, so the more important house, is controlled by the government, by the Law and Justice. But the Senate, the second house, is controlled by the opposition. So we have a kind of intra-parliamentary cohabitation. The Senate cannot block the legislation adopted by the Sejm, but it can postpone the legislative process. And if we take a look at some dates, the Sejm adopts the special statute on 6th April. The Senate's deadline for consideration of this statute is 30 days, so it expires on 6th May, and the vote is still going to be held on 10th May. So if the Senate keeps to this 30 days deadline, and then Sejm overrules the Senate's decision, it will be a day or two before the vote, and then you have 2 days to organize everything, to deliver 30 million ballot papers to citizens, because we have about 30 million persons allowed to vote. The post office has to do that, and then 30 million postal votes have to be picked from voters and delivered to electoral commissions. In addition, the governing party decided to transfer some powers from the National Electoral Commission to the government in order to force the conduct of elections, because they fear that National Electoral Commission would oppose this, well, simply speaking, quite mad idea. On 16th April, another statute came into force, on 19th April it came into force, and transferred even more powers from the NEC to the government. And it made the National Electoral Commission unable to conduct the elections. For instance, the Commission wasn't allowed to set the pattern of a ballot paper. It was the government's idea. What happened then? The Senate, of course, kept the statute, the special statute, for 30 days. It rejected it, but the Sejm overruled the Senate's rejection, and the statute entered into force on 9th May, so one day before the planned elections. But then there was a mutiny within the government. The Law and Justice Party was supported by two small parties, and the leader of one of them, Mr. Govin, leader of the party called Porozumienie, opposed it because he realized that it would be fatal for the state to organize elections in 12 hours and to pick 30 million votes in 12 hours. So he said that he will support the Senate's decision, and Mr. Kaczynski, the leader of the Law and Justice Party, could do nothing, because without the support of the small party, Porozumienie, he had no majority in the Sejm. So what happened? We had the strangest elections in the world on 10th May, elections without voting. The National Electoral Commission adopted a resolution stating that there was election, but no one voted, because there were no polling stations, there were no ballot papers, and so on and so on. So it forced the government, the Law and Justice Party, finally to talk with the opposition, and another special statute was adopted, this time in agreement, in a quiet political agreement with the opposition. And it was said that the campaign will restart from the beginning. It will be quite short, and there will be an option between voting in person and voting by post. And that's why finally the presidential elections were held. And as you can see, the turnout was quite high, 65% in the first round and 68% in the second round. President Duda was re-elected by very, very narrowly, like 51% to 49% that gained Mr. Trzaskowski, the opposition candidate. So what does this situation teach? Well, the OSCE, who drafted a report after the elections, claimed that the elections were free, but they were not entirely fair. As you can see, I quote an interesting sentence from the report, but it can be summarized with an even smaller sentence: don't be hasty in amending electoral law. Consider, talk, don't act as a madman. A rush is not a good idea when you amend electoral law. There are also problems with the public media, because they openly supported the President Duda, who was seeking re-election, and it was also pointed out by the OSCE. So, what to do in the future? There may be that such extraordinary situations like the COVID pandemic will reappear. So what to do with electoral law? I think the idea is to promote alternative forms of voting, postal one and proxy one. But I, as I think most Polish constitutional lawyers, have a reservation towards internet voting, because there is a threat of manipulation from abroad, and I think we know from which country will be interested in manipulating the elections. What to do then? I think we should amend the constitution. We should constitutionalize the principle which is called in Poland the legislative silence. It reflects to amending electoral law. It is prohibited to introduce important amendments of electoral law 6 months before ordering of the elections, unless there are extraordinary circumstances, but they have to be interpreted strictly. The principle is set by the constitutional tribunals in 3 judgments, but not by the constitution itself. I think we should rethink the prohibition to hold the elections during the state of natural disaster because it's too strict. If we have a natural disaster in a single commune in Poland, then the constitution prohibits to organize elections throughout the country. I think it's too strict. And I think we should consider allowing the extension of the vote to 2 days. Currently, the constitution, as interpreted by the Constitutional Tribunal, prohibits 2-day voting in Poland. I think if we lift this strict prohibition, we might simply distribute voting into a longer period, and that would may facilitate the turnout and maybe save some healthy citizens from meeting the sick ones. So, thank you very much. Once more, thank you for the honor to have been able to speak.
Thank you very much for presenting our Polish experience. Well, and I would like to ask Professor Laurynas Bieksza and Ilona Iwaszewskaite from Mykolas Romeris University for presenting migration law challenges in Lithuania during the second year of migration crisis. We are also, unfortunately, we are also familiar with the migration crisis. Yes.
So, good morning, everyone. So, my name is Ilona Schalte. I changed my surname, so my surname is Schalte, and it is an honor for me to thank you, to make the presentation at this conference. We prepared the presentation together with my colleague Laurynas Bieksza, and I will present the first part, and then he will present the second part. And I'm afraid that this presentation about the Lithuanian reaction to the migration crisis is going to be even sadder than the previous presentation of Dr. Piotr Sibalski. So at least I hope that this conference will have no more such a sad presentations after this one. So today we are still talking about the changes in the migration law caused because of the migration crisis and the emergency situation. So emergency situation was announced. So, emergency situation was announced on the 2nd of July of 2021 and still going on. And reacting to that, pushbacks were legalized by the order of the Minister of Internal Affairs. Also, restrictions to submit an asylum application when a person came irregularly were introduced, and in the law it was said that any person who crossed the border irregularly shall not be admitted to the territory, which means shall be expelled. And if we are looking into this regulation from the point of European Union law, it is quite clear that these amendments are incompatible with the European Union law. So firstly, decisions on expulsion must be issued in written form and individually. If we are looking into a return directive, into the Schengen border code, and into European Union asylum law regulation. But what it is most important that access to international protection cannot be restricted at all. And similar situation was in Hungary during the migration crisis in 2016, and similar restrictions were introduced in Hungary. So in two cases against Hungary, European Union Court of Justice pointed out that any third country national has the right to apply for asylum in the territory of a member state, even he or she is staying illegally. And member states must ensure an effective access to asylum. So those two rules was very clear that a regulation which legalize pushbacks are incompatible with European Union law. But our regulation was set into the law, even this case law existed. So the same rules were repeated by the court in the case MA versus Lithuanian State Border Guard Services, and court stated that European Union law does not allow regulation when even in the state of emergency, which restricts access to the international protection. So the fact that Lithuanian laws are incompatible with European Union law was confirmed by the Court of Justice of European Union. And what happened next? So Lithuanian national courts took into account this decision, but however, almost 1 year there were no action from parliament or government to make any changes to those laws. So only at the end of April, the law on legal status of foreigners was amended, and the restrictions to submit an asylum application has been lifted. However, pushbacks were not lifted, but instead of that, pushbacks has been introduced in the law passed by Parliament, as it was before it was in the bylaw. Now we have those pushbacks legalized in the law. And to balance a little bit national security and human rights, law set the exemption that obliged the government to adopt a list of countries from which foreigners cannot be pushed back because of armed conflicts. But what happened? The Lithuanian government has dropped this exemption, and this list was not adopted. So, however, even we have a European Union Court of Justice decision, which says that our regulation is incompatible. The situation is still going on. So thank you, and Laurynas will talk about the detention.
Yes, I will continue about the second problem, which is de facto mass detention. And situation is getting better. It's not so bad as with pushbacks, but still we have this problem left to some extent. So just very quickly, I will remind that the worst situation was in 2021. At that time, all foreigners coming to Lithuania, they were for half a year kept in detention without any judicial decision, without any decision at all, even no administrative decision, just people, families with children, everyone, like 4,000 people, 1,000 of them children, they were kept in detention for 6 months. And no access to legal aid, no access to judicial review. So this was the beginning of this migration influx. Then, 2022, our parliament decided that after keeping migrants, asylum seekers for half a year in detention without any decision, without any procedure, after half a year, it is possible to continue them to keep in detention, but this time at least with administrative decision, extending their detention for 6 more months. And this time it became possible at least for the foreigners to get lawyer and to go to court to review that already second term of detention. Second 6 months, they already became, appealable with the possibility to go to court. And at the same time, good thing happened that violation was obvious. But in Lithuania, we simply ignored international law and European Union law, and we waited till the court will address Lithuania personally. So finally, the court addressed Lithuania personally, and in 2022, EU Court of Justice told that it is illegal to detain asylum seekers simply for the reason that they came without documents. Even in the context of migration emergency situation being declared, it is not valid ground to detain people. So EU Court of Justice made that decision concretely about Lithuania, and following that decision, during the summer of 2022, our courts released all migrants from detention. It is sad that it took so long. It took approximately 1 year to keep people, like you see, families, children in detention, but at least it's better later than never. Asylum seekers and migrants, they were released in the middle of 2022. And today, 2023, we still have one problem going on, kind of inherited from the regulation of our emergency response. So new asylum seekers who are coming to Lithuania and whose asylum applications are examined under accelerated procedure, they are also placed in detention without any decision, without the possibility to appeal. So initially it was aimed just to address emergency influx in 2021, but this rule remained in the law. So new asylum seekers who are unlucky today that they are coming and receiving accelerated asylum procedure, and actually many asylum seekers in Lithuania receive the decision about accelerated asylum procedure, they are kept in detention, again, without any decision and without even the legal aid or possibility to go to court to review their status. If they are lucky, if they have money, if they can hire a private lawyer, yes, they can go to court and they are released. Because this is nonsense. This is nonsense, this is clearly illegal. But only if they are lucky, to take care about themselves. If they do not have money, they are in the detention, I will repeat once again, without any decision, without any procedure, so it is not good. Yesterday, our Constitutional Court started to examine this issue. Yesterday, it was first written hearing on this issue. I'm not sure how long it takes for the Constitutional Court to finish its examination and issue the decision. So I hope it's not going to be too long and we will get the Constitutional Court decision addressing this problem. And also, a very similar case now is pending against Lithuania in the European Court of Human Rights. So probably this will take longer. I hope that Constitutional Court will solve these problems soon, and if Constitutional Court fails, then I hope at least that European Court of Human Rights will solve this problem someday. So to summarize maybe my part of presentation and Ilona's part of presentation, it is in the field of detention, we see that it's good that at least law is catching up this emergency situation later, yes, after people suffering for 1 year or even for a longer time, and law still catches up that situation and amends that situation. It takes time. And in the field of detention, that would be the example, that law is slow, but still it gets the situation amended according to the law. But I am very sad about the first part about pushbacks, about illegal practice of pushbacks at our border. We have complete ignorance of EU law, international law, even like Ilona told, our government ignores the law of national parliament. Our national parliament 2 weeks ago told, okay, you can keep pushing people back, but at least make the exception of the list of dangerous countries. It was like law issued for the government. Government told, no, we are not going to make that exception. So our government ignores everything. So it's not strange if we ignore international law, why shouldn't we ignore national parliament? So we are in this situation today, and I hope that if we will have a presentation during the next year conference here, we will tell that finally the law catched up even in the field of pushbacks. So thank you.
Thank you very much to all presenters. I have an impression that we will postpone the discussion up to the ending of the next panel, I think. And coffee break, it will be coffee time. Thank you very much.
your challenges in Eastern and Central European countries. And now panel 2. I am Toma Birmontiene. I will moderate this session. I hope that everybody will be in time. And this, our session, we will be, it is a pleasure for us that we will have 5 speakers. So I hope that every speaker will keep to 15 or maybe no maximum up to 20 minutes, no more, because after this session we have a lunch break. I think it's also very important during all conferences. So the first, this speaker at this panel is Professor Edyta Sokalska, University of Warmia and Mazury in Olsztyn, Poland, searching for the ideal form of a state, social participation and participatory instruments in the local level, the Polish example. Please.
Thank you very much for the opportunity to speak. I would like to make some remarks concerning the idea of the state. I'm searching for the ideal form of a state. I'm trying to do that. And I will make some remarks concerning social participation and participatory instruments at the local level. Of course, it will be the Polish example. Increasing dissatisfaction with the current form of democracy stimulates a constant quest for the way to improve it. Democratic transformations take place in both, I mean the doctrinal and institutional aspects. And in the 20th century, in the practice of European democratic states, the, I would say, indirect procedural representative democracy was dominated by the institutional censorship, the exercise of citizens' electoral rights, and the control over the activities of representative bodies by the voters. And public disappointment with the effectiveness of such forms of democracy, of this form of government, the alienation of citizens resulting from the feeling of illusory influence on politics and dissatisfaction with the negligence of the decisions stimulated the search for the solutions to the crisis of representative democracy. And the response to the crisis of representative democracy in the 21st century may be deliberative democracy, sometimes called participatory democracy. The quest for opportunities to improve the current system results from the incompatibility of the present solutions to the times we live in. Since the time when democracy became the leading system of government of the countries of Western culture, it has been undergoing transformation, constant transformation. The changes occur at the doctrinal and institutional levels. Institutional changes concern the organizational and institutional forms. Some issues relate to the ambiguity of the contents of ideas connected with the respecting the rights of minorities, the efficiency of decisions, the alienation of citizens. In fact, deliberative democracy its ideas have attracted the attention of citizens, political activists, and state organizations in countries around the world. It influenced the tendency of decentralization of public administration in some post-communist states. In the 90s of 20th century, the process of creation of legal acts regarding the participation of citizens in public life in Europe can be observed. It is also worth to emphasize that these acts were issued on various levels. I mean local, state level, and international level also levels. They concerned the participation of on various fields such as social affairs or ecological security. Since then, the role of social participation has become more prominent, more noticeable, and it has become indispensable condition for social acceptance of decisions taken in the developed democratic countries. The transformation of Polish political system in the late 80s of 20th century created some favorable conditions to the development of the process of decentralization of public administration and to the changes in the structure of state apparatus. We can ask some questions concerning the idea. The main questions could be: what are the modern forms of social dialogue at the local level in Poland? What are possible dysfunctions and barriers of social consultations as far as Polish solutions are concerned? Do social consultations at the local level play an important part, an important role in the Polish public life? Or the question, how Polish municipalities contact and inform their inhabitants about consultations? If I had more time, I would present some more information concerning participatory or deliberative democracy in the scientific discourse and social dialogue, but I think that I will move longer to the second part devoted to Polish solutions. As I said, deliberative or participatory instruments are the subject of a scientific discourse. The solutions interested some scientists all around the world, and some American authors named even deliberative democracy or participatory democracy. American scholars as James Fishkin or John Drizek, they underlined the importance of new solutions concerning the development of deliberative democracy, and they are the fathers also of the terms in some way, of course. The fall of communism and the elimination of some considerable threats connected with this kind of political regime brought the different attitude to the liberal democracy in post-communist states. In old and new democracies, we can observe the intensified social individualism, the degradation of family and moral values, and the lack of confidence in political class. As far as old and new democracies are concerned, I don't like it, the division. But of course, we have it in the legal discourse. The academic research and scholar reflection devoted to representative democracy, I think that it turned out to be effective at last. Some of the solutions of deliberative democracy were willingly adopted in the post-communist countries in order to meet new social and political needs. Yes, and I can ask a question if you like that house. It's a curve house. Krzywy Domek. It is located in Sopot, Polish town by the Baltic Sea, Polish resort. And if I ask the question, do you like it? There should be different answers, because some people can say it's very nice, it's interesting, and some people say it's strange, I don't like it, yes? So the same is in deliberative democracy. I think there are different points of view presenting different ideas. Common form of consultations at the local level in Poland are meetings of inhabitants, survey forms, meeting of the local authorities and local representatives with the inhabitants of local administrative districts, research on public opinion using some electronic questionnaires, consultation cards, receiving opinions and proposals, making documents referring to subject of consultations available to the public. But unfortunately, we haven't, there aren't any uniform platforms for consultations. Any uniform platform for consultations has not been created. The consultations are carried out via internet sites, konsultacje.gov.pl. Some of the internet platforms are rather informative character than consultation character. Information and communication technologies, ICT, mold public opinion and shape the subjectivity of citizens as far as the relationship with the state structures are concerned. On the local level, they are used in order to build a dialogue between local self-government and local society, understood in a broad way, local inhabitants, NGOs and entrepreneurs. And with the development of significance of the internet, local authorities more frequently transfer the conduct of public dialogue into the virtual reality, especially its fundamental forms as information, consultation, and co-decision. As far as Polish experience is concerned, I have to say that Polish local municipalities apply two kinds of the websites. The first is obligatory, is Bulletin Informacji Publicznej, BIP. The second one is an official website of the Gmina Administrative District. There are diverse instruments to carry out the public dialogue on mentioned websites, which provide municipalities with the freedom of participation in the decision-making process. So ICT technologies give the opportunity to faster exchange of information and answers to the local problems. The research on the ICT shows that the fundamental dimension of the public dialogue, I mean information, is realized via BIP. Information enriched with the service functions is realized by local administrative bodies via EPUAP platform. And for bilateral communications and consultations, there are used some networking sites, chat, forum, commenting online, dialogue boxes, and questions to administrative bodies of a variety of formula. As far as consultations and co-decisions are concerned, there are applied some more sophisticated and expensive tools which follow the patterns of the states, presenting the higher level of an information society. For example, your budget, twój budżet in Warsaw, as far as I know, and also different in different cities, different towns. It is significant that rural and urban municipalities apply different ICT in the context of better financial opportunities and better access to internet of citizens. Urban administrative units create even a few internet sites devoted to specific matters, which consequently form a coordinated system of information, consultation and co-decision. Rural municipalities have to adjust the tools to their capabilities. In this context, the websites are applied rather more frequently to inform than to consult. It can be also observed that the official websites of the administrative district located in neighborhood, they are similar, they look quite similar. So there are, of course, some possible flaws and barriers of consultations which are indicated here. Thank you very much for your attention. Thank you very much.
And you touched a very important pattern and a very important subject. Of course, and I just was listening and thinking how we speak about our states. Nowadays, of course, democracy, liberal, non-liberal, so we find the ways how to find the ways. But before 90s, that part of the World War II, something like that, because it's for our states it's even earlier. What kind of state we are? And sometimes, very often, I hear post-communist, post-communist. What does it mean, post-communist? Whether Poland was post-communist, Lithuania was post-occupied. Now, yes, because the time after the World War II, maybe it is a little bit even more, 40s, yes, the same as with Poland. Lithuania is very clearly, it was an occupied state regime. So Polish system was a little bit more, how to say, trickier. but nevertheless wasn't free. So why we use these notions? Maybe it will be very interesting for our next seminar just to discuss how we call because in these cases, post-Soviet, post-communist, but not post-occupied. I never had it. It's my innovation. So, but maybe we have to discuss somehow. How can we call that period of time? Because, for instance, in Lithuania, it's very clear that we say that it was a time of occupation. So, communism, I don't know, Poland maybe also didn't see any communism. Soviet, quasi-Soviet regime maybe. So I think that maybe, thank you very much, Edita, for your presentation. That also raises some questions and some problems and maybe gives a very good input for our future discussions. And now I would like to ask Ieva David-Nikolaitė, professor of Mykolas Romeris University, well-known scholar for all of us, one of the organizers of this conference. And here, title of the presentation, Innovations in Legal Regulation of Local Self-Government in Lithuania. So a little bit very close to your presentation, but we will.
So very recently we made amendments to our constitution to the article which is related to local self-government in Lithuania. Here you see this article, the old version and the new one. So here you see that mayors were attached to the article 119. To this date, we did not have mayors in the constitution. However, from 2015, we elect directly mayors from 2015 March. But this institution was not in the constitution. So you see, mayors. And this provision was cancelled, quashed. For the direct implementation of the laws of the Republic of Lithuania, the decisions of the government and the municipal council shall form executive bodies accountable to it. So mayor was elected directly, but he was not an executive institution. He was a part of representative institution in the local self-governance of the Republic of Lithuania. According to Constitutional Court, law on local self-government provisions contradicted to Article 119 of the Constitution, because according to the law on local self-government, which was in force before the amendment of the Constitution, so you see, which is headed by the member of the municipal council, mayor. So mayor was a member of the municipal council, and at the same time we elect him. The mayor shall be the head of the municipality who exercises the powers provided for by this law and other laws. Then another Article 5 of the law on local self-government, according to Constitutional Court, also contradicted to Article 119 of the Constitution. And here it is said, public administration functions shall, in the manner prescribed by law, be exercised by the municipal council, the mayor, an executive institution of a municipality, etc., etc. Article 15 of the law on local self-government, again, it is interesting because we elect mayor directly, who was not mentioned in the Constitution, and he was at the same time the member of the council and the president of the council, because he presided over the meetings of the council. Moreover, when number of votes of the council distributed equally, mayor's vote was like fatal, yeah? Mayor shall have a casting vote. But mayor was not mentioned in the Constitution. So Constitutional Court determined when it examined travaux préparatoires of this law on local self-government that mayor had at least three functions. Powers of the head of the municipal council, the powers of the mayor as an entity of local government, and public administration powers, including to perform executive activities, to implement legal acts, laws, government resolutions, and decisions of the municipal councils. Constitutional Court, when it ruled, when it declared, yes, these views in its decision, it relied on European standards for the functioning of political representative and local self-government institutions. These standards, like, for example, European Charter of Local Self-Government, provisions of European Union law, and other various recommendations, opinions, etc., etc. And according to these documents, usually, mayor is an executive body, not a representative body at the local municipality, but executive body. So they followed these documents, and also Constitutional Court determined that Article 119 does not provide for any exceptions to the principle of equal mandate. So we had directly elected mayor, which is not mentioned in the Constitution, which had a fatal vote, you remember this fatal vote, but he's not mentioned in the Constitution. And it looks like we had a mayor who was a member of the council at the same time, and who had exclusive status, exclusive legal status. So, but Constitutional Court said Article 119 does not provide for any exceptions to the principle of equal mandate of the members of municipal councils. So, moreover, it said that the Constitution does not establish the position of the head of municipal council directly elected by the relevant local community. Yeah, it was not said. Thus, under the Constitution, according to the Constitutional Court, the executive bodies accountable to municipal councils may not be formed from among the members of the municipal councils that establish the said bodies. So mayor was a part of representative body, not executive body, but we had executive body as an administration, director of administration. And this director of administration and administration was formed, and the whole administration was formed by the members of the municipal councils. So under Constitution, Constitutional Court determined that the executive bodies accountable to municipal councils may not be formed from among the members of the municipal councils. So, you see. And, yeah. Moreover, Constitutional Court determined that it should also be noted that as paragraphs 1 and 2 of Article 119 of the Constitution does not establish the position of the head of a municipal council directly elected by the relevant local community. So it means that either we should stop directly electing mayor, or we should make amendments to the Constitution and to the legal regulation, to the law on local self-government. So Constitutional Court said the impugned legal regulation of the law on local self-government establishes the municipal institution and the member of the municipal council, the mayor, which is not provided for in the Constitution. This institution is neither a representative institution nor an executive or other institution formed by means of a decision taken by the municipal council. So the legal status, the legal role, the legal position was not 100% brilliantly clear, or whether the clear of the mayor, you see? So the local community and the head of the municipality as a community of an administrative territorial unit of the state. Moreover, Constitutional Court repeated that such a legal regulation should be assessed as violating the principle of the equal mandate status of the members of municipal council, because we had a member, council, mayor, with a special status that was not governed by the Constitution. Therefore, Constitution was changed, and from 1st of April 2023, we have a new law on self-government. Under this new legal regulation, council is a representative body as it was, mayor became an executive body. However, he or she does not direct administration. Administration is directed by the director of administration as it was before. No more casting vote of mayor and some other aspects. Concluding, amendments to the constitution certainly should be done. If we elect mayor directly, it must be set out in the constitution, and it was done. But globally speaking, the new legal regulation changed nothing, of course, in daily life of a citizen. Meanwhile, mayor's activities became difficult. We have not still created acceptable form of municipal executive institution in Lithuania. More analytical and comparative studies are needed. Thank you.
Thank you very much. You have touched really very important case. We have new local governments, we have new constitutional arrangements, and we have new problems in elections, because we have new electoral code, and it showed that these last elections of our local councils was really some kind of a theater. There were so many problems, so many, how to say, inaccuracies that it also could be just another subject for our discussions. But now we have to move on, and the next to come on a remote way, and it is online, and I would like to ask whether Professor Juraj Vacok is online. So, Professor is from Slovak Republic, Comenius University in Bratislava, and his presentation, Unsuccessful Attempts to Codify Administrative Punishment in the Slovak Republic. Now, the title, very interesting and very, how to say, very important for all of us, because these attempts to codify punishments is all over, is a problem all over. So please.
Okay. Thank you very much, Speaker. At the beginning, I would like to ask if you hear me.
Yes, we do, but a little bit louder would be better.
Okay, I will try to be louder.
Thank you.
One more time, many greetings from Slovakia, from Bratislava, and also thanks for the possibility to join this conference with the topic which is quite actual and in Slovak Republic. I chose this topic because of two reasons. The first reason is that we have in our academic environment many discussions still about the future of administrative punishment, and the second, that we have the special project for this problem. Truly, today my presentation is based not on the facts, but truly on the questions, because we are still in the very deep discussion about the future of administrative punishment, and I will try to show why. Because of that, today I will talk very brief about the history of administrative punishment in the Slovak Republic and former countries, the changes of the former concepts, and I will try to in my conclusion to show to some problems, and maybe to take advices from you how to go in the future. We have still the same question, maybe for 30 years from the beginning of the separate Slovak Republic, how to create a system of administrative punishment in the Slovak Republic. And unfortunately, this question is on the table still now, and is still actual. actual. When I want to talk about the administrative punishment, I only want to notice that our system is, I think, very similar with Poland and also very similar with Lithuanian system. We have our proceeding, administrative proceeding, and also it's including administrative punishment has 2 levels. The decision of the first instance administrative body who decides about the particular administrative delict and about the guilt and also about the sanction. And we have the appellate administrative body. After that, the parties may go to the administrative court, but the position of administrative court is the position of the cassation court in general. After that, there is the extraordinary remedy that the Supreme Administrative Court of the Slovak Republic and the best traveler may go also to the last instance, and is the Constitutional Court of the Slovak Republic. This is very briefly to the proceedings in the Slovak Republic, and let's go to the history in the Slovak Republic. In the Slovak Republic, we must say that, in former Czechoslovakian former system, we strictly divide between administrative punishment and criminal punishment, but we must say that the line between administrative punishment and criminal punishment is very thin. Mainly, the question where should be administrative punishment, what should include to administrative punishment and what should include to the criminal charges or criminal law is mainly on the arms of legislature. Legislature in general, we may say that criminal punishment should include more serious wrongs or wrongful actions, etc. But now also this criteria is in practice not fulfilled, because we may see that also some serious, for example, wrongs of legal entities also belong to administrative system of administrative punishment. When we talk about our history of the Czechoslovak Republic and now history in the Slovak Republic, we may start with the Criminal Administrative Act, which was in force since 1st August 1950. And we must say that this act, Criminal Administrative Act, has a very special position, and what is interesting, this act also allows to punish the people, for example, with the sanction which is imprisonment, which is not today possible. But also what is interesting that in our history we had the act which according to which not judge but administrative clerk might send people to the jail. This act was renewed by the Act 60, 1961, and now we have still enforced the Act 372 from the year 1990. When we talk about these acts are connected, or these acts regulate only the minor offenses. We have also another kinds of administrative delicts, but the regulation of these delicts is very poor. Usually we have some provisions in special orders, and these provisions are supported with the general law on administrative proceedings. This is about the brief history, and this is also about maybe something like peaceful life to the year 1998, when in the Slovak Republic the European Court of Human Rights decided two cases, and these cases the European Court of Human Rights said that also minor offenses should be considered as crimes according to Article 6 of the Convention, European Convention of Human Rights, and this was the first point from which we should start to talk what we effectually do with administrative delicts and what we do with administrative punishment. The situation was developed in a very strange position, because we still had the administrative punishment, but the courts and also the laws started to regulate that we should apply criminal principles from criminal law, substantial criminal law, and criminal procedure law. And now when we still develop the system, we still do not have the exact criteria what should be applied from criminal law in the field of administrative punishment, because we have still we are still in the principle of subsidiarity of criminal law. And of course, the second question which is connected with this is how is the character of administrative punishment today? Because if we want to subsidiary with the principle of subsidiarity, if we want to apply the criminal law, we also change the procedural nature of this administrative punishment, and the administrative punishment starts to have more closer to criminal law with regards in compare with the proceedings in compare with administrative proceedings. Now we have been very strange position, because on the one side we have still administrative punishment where the deciding making bodies are administrative bodies, but on the other side we have the request to the administrative bodies to apply basis of criminal law, and because of that to apply basis of criminal law and push the whole proceeding to the proceeding with the similar with the criminal nature. Despite this fact, we still remain the administrative punishment on the arms of administrative bodies, and we still say, okay, you are administrative bodies, you should do you should fulfill the request of Article 6 of the Convention, you should fulfill the request of the principles of criminal law, but we still don't have to fulfill one of the requests, and the request of Article 6 is that we still don't have in the line of administrative bodies, we don't have the independent bodies, because we have here the administrative authorities, and administrative authority don't have the level of independence which is required for the courts. It's true that our courts may review the decisions of administrative bodies, but we must say that they only reviewing the decisions, and usually they do not, for example, make evidence and etc. And because of that, the main position is still on the arms of on the arm of administrative bodies. And because of that, we are still, and it's very interesting that we are still at the beginning. I think we are still at the beginning because we are still at the beginning of the discussion. What will be the nature of administrative punishment in the Slovak Republic in future? We know that we should create, and we try to create also legal act, special legal act for the whole legal punishment. But the development to the future seems to be that the administrative punishment will go still closer to the criminal law, and we will see maybe in the future we will have only one law which is connected with public punishment, which maybe will contains criminal law and law of administrative delicts. Dear colleagues, I would like to present you my our main topic of our discussion about administrative punishment, and I would like to thank you for your attention, and maybe within the debate I will be very glad or in the future about your statement and maybe comments or viewing how should be the development of administrative punishment, not only in Slovakia but in all countries, if we go with administrative punishment closer to criminal law according to Article 6 of the Convention, or if we will be able to remain the administrative punishment in the corridors of administrative law, how we know it historically also in the Slovak Republic. Thank you very much for your attention, and if you will have any questions, comments, I will be very glad in the discussion. Thank you very much one more time.
Thank you. For a very interesting presentation, and of course for the problem that is very actual not only for the Slovak Republic but and for Lithuania and for other countries. That line between administrative and criminal delict. It is a very, very, how to say, from one point of view it's very easy, you can take the punishment maybe or something like that, some kind of criteria, but in principle it is really very difficult, and even in Lithuania we were changing legislation, adopting some codifications, but still discussions exist. Whether administrative delict is really, we call it administrative delict, but in reality it looks like a small criminal delict. So it's very difficult what we call, what is the real subject. So thank you very much for your interesting insights. And now another our colleague, also from Comenius University, Bratislava, the Slovak Republic, Professor Julia Vaščenko. The title of her presentation is a little bit different, but very actual for us, as we were living in a very difficult times. It was an energy crisis, so maybe some solutions will be given through this presentation. The title of the presentation is Legal Status of the Energy Regulators in the Slovak Republic and Ukraine. So please, dear Julia, are you with us?
Yes, dear Tamar,
Nice
good day,
to
dear
see
colleagues.
you. It's a pity that you
I
are
hope
not
you can hear me.
here in the room, so please, time is yours.
Good day, dear colleagues. I hope you can hear me and see. Yes.
Yes, we see and we hear you. Okay.
It's my great pleasure to participate in this event, in this fruitful discussion. So thank you very much for giving me this opportunity. Today I would like to talk about some important issues related to the legal status of energy regulator, and I would like to talk today about the peculiarities of the status of energy regulators in two countries, the Slovak Republic and Ukraine. In Ukraine, the status of energy regulator is under debate. It had been under debate for many years, and even it was subject to constitutional hearing, hearing by the Constitutional Court of Ukraine concerning the place of the energy regulator in the system of public authorities, and concerning the powers of the President of Ukraine, the Parliament of Ukraine related to the energy regulators. So it's very important to analyze foreign experience in this matter, how the status of the energy regulator is established, what are the core elements, what are the peculiarities of its regulations. So I think it should be interesting, useful to compare some aspects of the legal status of energy regulators in the Slovak Republic and Ukraine, and probably to elaborate some recommendations concerning the, in particular concerning the improvement of the legal regulation of the status of energy regulator in Ukraine, taking into consideration the experience from the Slovak Republic. Talking about the peculiarities of the status of energy regulators, I must say that it's related to the such concept of economic regulation in general and energy regulation in particular. And there are special requirements in the EU. For the Slovak Republic as a member of the EU, and for Ukraine in frames of EU-Ukraine Association Agreement, and early in frames of Energy Community. Ukraine is a full-fledged member of the Energy Community from 2011. So two main legal acts, two directives, electricity and gas directives that are established, that establish requirements on national regulatory authorities that should be established at national level in the EU member states. And these directives stipulate the core requirements on such special regulatory authorities related to the encouragement of independence of national regulatory authorities in energy field from any public or private interest, in particular related to independent decision making, adequate funding, adequate human resources, accountability, principle of cooperation with other public authorities, and guarantees for independence of members of the board or top management of such authorities, in particular related to requirements to such top management, issues, procedures of their appointment, dismissal, and funding. Talking about the basic legal basis for energy regulators in the Slovak Republic and Ukraine. So there are special regulation or special laws that is regulate the legal status of energy regulators. Such authorities were established in Slovak Republic in 2001, in Ukraine in 1994, and special laws were approved on their status. Concerning the place of such authorities in the system of public authorities, so according to the law of the Slovak Republic, energy regulator, the state authority with powers over the whole Slovak Republic, and this authority is independent from both state power and regulated entities. So taking into consideration this system of public authorities, such authority as energy regulator, the title is Regulatory Office for Network Industries. And this authority belongs to the group of special public authorities, state authorities with powers over the whole Slovak Republic, and this group covers in particular such regulatory authorities and supervision authorities. Concerning the place of Ukrainian regulator, and in Ukraine it's National Energy and Utilities Regulatory Commission, which has a special law on National Energy and Utility Regulatory Commission. It was approved, by the way, in 2016. This body belongs to the group of special central bodies with executive power. The title of this group, Central Bodies of Executive Power with Special Status. And this authority established by the Cabinet of Ministers of Ukraine, the government of Ukraine. But such place in the system of public authorities in Ukraine for the energy regulator was not permanent, and here you may see the evolution, we can say, of the status of National Energy and Utilities Regulatory Commission in Ukraine. So from the early beginning, this authority was established as independent authority outside the system of bodies of executive power, and it was like permanent, independent authority, governmental. And next step, this authority was included to the system of bodies of executive power with special status. And this special status was regulated by special regulations. Next step, again, the Commission was provided with special status, but outside the system of bodies of executive power. And at this stage, the special organizational legal form was introduced as a state collegial authority. And this Commission and some other public authorities were provided with this organizational legal form, state collegial authorities. That this group of authorities was excluded from the vertical of bodies of executive power, so they were not the bodies of executive, central bodies of executive power, even with special status. So it was, and it is because this organizational legal form is still used, but for some other bodies in Ukraine. So it is a special group of public authorities that is not included into the system of bodies of executive power. However, this special status was under debates among professionals, among scientists, practitioners, and even was subject to the consideration of the Constitutional Court. And according to the judgment of the Constitutional Court, actually these provisions of the law on, in particular the law on the National Energy and Utility Regulatory Commission, were considered as unconstitutional. The following arguments were considered. First of all, the constitutional provisions that do not include special norms concerning state collegial authorities, and the Commission is not included to such special group, and it is not possible to establish such authorities that do not belong to legislative, executive, or judicial branch of power. So such interpretation was used of the constitutional provision. And next argument concerning the powers of the president of Ukraine, because it was, according to the law, it was the power of the president of Ukraine to establish such authorities, the state collegial authorities, appoint and dismiss its members and regulate their activities. So based on this judgment of Constitutional Court of Ukraine, special amendments were made to this law on National Energy and Utilities Regulatory Commission and some other laws and regulations in Ukraine. And currently the energy regulator in Ukraine has a status of central body of executive power with special status, subject to the regulations, in particular established by special law on central bodies of executive power. So this law also includes like a special type of central bodies of executive power, central body of executive power with special status, and the energy regulator belongs to this group also according to this law on central bodies of executive power. However, some bodies still enjoy state collegial authority, and also some commissions, regulatory commissions, have this status, and therefore special provisions on the regulation of the status of such state collegial authorities are included in the special laws that establish the status of such authorities, and in particular related to their establishment, regulation of their activities, appointment and dismissal of their members, etc. One very important issue actually related to the independence of energy regulatory authorities, it's regulation of the managerial bodies of such authorities, and talking about the managerial bodies of the energy regulator in the Slovak Republic. According to the law, there are chairperson and the regulatory board that consists of 6 members. In Ukraine, the energy regulator is collegial authority, which consists of 7 members, including the chairperson. Concerning the appointment and dismissal procedure of top management, managerial bodies of the regulators. So talking about the energy regulator in Slovak Republic, chairperson appointed for 6 years and dismissed by the government of the Slovak Republic, vice chairpersons appointed and dismissed by the government upon the proposal of the chairperson of the energy regulator. Members of the regulatory board appointed and dismissed by the president of the Slovak Republic upon the submission from the parliament 3 members, and from the government also 3 members. And the head of the regulatory board appointed upon the proposal of the board and dismissed upon the submission of the board by the president of the Slovak Republic. In Ukraine, according to the law, members of special procedure actually is established by the law, and members are appointed upon the results of open competition conducted by the special competition commission. And chairperson is selected by the members of the energy regulator for the period of 2 years. Concerning this procedure, by the way, it is currently taking place in Ukraine, selection procedure of future members of the energy regulator, and some practical issues arisen due to these changes in the legislation. And I would like to talk about some of them. So concerning this commission, it consists minimum of 4 members and is established by the government of Ukraine. But the candidates to this commission is submitted by the parliamentary committee responsible for fuel and energy complex and utilities. three candidates, one from the ministry responsible for energy and one from the ministry responsible for communities, territories and infrastructure development of Ukraine. And this commission conducts selection procedure. Then the list of candidates with the highest results is submitted to the government, and the government chooses from this list and appoints the members of the regulator. One very important issue related to the status of members of managerial bodies, and here I would like to pay attention that in the Slovak Republic, chairperson and vice chairpersons, they have the status of civil servants, however, with special regulation concerning their salary. And members of the regulatory board, they perform a public function, and there is special regulation on remuneration defined by the law. In Ukraine, concerning the employees of the central apparatus and territorial bodies, they have the status of civil servants. According to the law, it's strictly defined, but concerning the members, chairperson and members of the regulator, it is the question on the debate, and by the way, currently candidates who decided to participate in this competition, they faced the problem of how to define this position in the procedure, because there is no special provisions on the status of the chairperson and members of the regulator, so whether they are civil servants or not. And based on the provisions of this status law on the energy regulator and other laws, it is difficult to answer this question. So actually, strict regulation is needed. And taking into consideration the current legal regulation in Ukraine and still debate on the elements of the status, some of them I mentioned today, and taking into consideration the foreign experience and in particular the experience of the Slovak Republic, I would like to make such recommendations actually about the improvement of the status of the energy regulator in Ukraine. So to return to discussions about the independent status of such regulatory authorities, concerning the procedure of appointment and dismissal, so in my opinion, actually several subjects should participate in this procedure, namely the government, the parliament, and the president. And also it's important in relation to accountability of the members. And talking about the status, so it is really important to define the status of the managerial authorities, so namely members of the regulator in the law. Whether they are civil servants or not, in my opinion, they should not be subject to the general provisions on civil service, and in particular in relation to their remuneration. Okay, so thank you very much for your attention. My time is over. I would be glad to hear your questions. Thank you.
Thank you very much. Thank you very much. In the end of this session, if there will be questions, of course, we will be happy to raise them, and I hope that all participants will have possibility to answer. But now we are going on, and now it's a great pleasure for me to invite Professor Dorota Elise Staranovic, University of Warmia and Mazury in Olsztyn. And the title, The Right to Sign Languages Between Theory and Practice. Of course, for us, dear Dorota, is a very big question. What does it mean? What is that sign language, and how it works in the law and in the constitution or administrative law?
This one? Okay, this one. First of all, I would like to welcome all into language. Polish and Lithuanian language. Of course, My pronunciation is terrible, I know about, and Joseph knows about it perfectly, about this, but Labadiena. But there is another Labadiena in Lithuanian sign language, is Labadiena in Lithuanian. In Polish we say dzień dobry, but Polish deaf citizens speak different, speak dzień dobry, dzień dobry. Dzień dobry, it's Polish sign language. There are several factors that I decided to present this topic first of all because I changed the topic of my research in Poland because the Polish politicians are deaf. So I decided to interested the rights of deaf in Poland, not only in Poland but around the world. And it's the first factor. The second, I couldn't find any interesting articles in Poland about the linguistic right of deaf. The same situation is Lithuania. The Czech Republic, my colleague from Czech Republic, when I called him asking, could you help me and send me several articles about the linguistic right in Czech Republic, first he asked me, what does mean Czech sign language? What does mean Slovak sign language? So I decided to present this short paper about the linguistic rights of deaf in Poland, not in Poland, in Europe. I share the idea that language reveals the engine of our soul, our mind. It illuminates us and energizes us. We share it with all we meet. It's a cognitive fire of human life. And therefore, the language is a fundamental value to man, and this fundamental value is protected by the law, and the linguistic rights are protected by law as a fundamental human right. The legal protection of official language of minority, often appears in legal journals, and this issue is well recognized and described. Yet this is not the case with the right of deaf in Poland and Europe as well. This subject really seldom appears in legal discussion. Legal academics are interested in the legal status of Polish language, Lithuanian language as a minority language in Poland, as well German language as a language minority in Poland, but there is no article, there is no book about the linguistic rights of deaf. For decades, the language, the silent word was outside the scope of interest of the legislator. Deaf people are the needs for recognizing the term of social assistance, and states focus on effort to provide primary education or trade education, social benefits. And the rights of deaf were derived from the disability, and it was confirmed by or in Convention on Rights of Persons with Disabilities. I regard that approach to sight problem as misguided because sight language and the problem of deaf people should be placed in a different legal context than merely disability. We should focus on the sign languages. Sign languages are fully fledged and natural languages. There was a lingering misconception their languages were primitive or devoid of grammar rules for many, many years. And this myth collapsed due to the research, due to the Professor William Strong. He conducted research on American Sign Language in the last century, and he proved that American Sign Language is a natural language with their own grammar, syntax, morphology, etc., etc. It's a full language. And moreover, he proved that sign language are national language because they stem from the culture, they stem from the experience of the deaf society. And another myth collapsed. The sign language is not the universal system of communication like Braille for the blind. So the deaf speak Polish sign language in Poland. The deaf speak Lithuanian sign language in Lithuania. There are some similarities between Polish sign language and French sign language, but it's old story. It's another story, the subject for another conference. Polish sign language was born around 1870 at the Institute for the Deaf Mute as a boarding school. This school still exists in Poland, near the building of Polish Parliament. It's a very famous place, Trzech Krzyży, Three Cross, very famous place in Poland. And this school was founded by priest Jakub Falkowski. And the first dictionary was published in 1879, the first dictionary from Polish Sign Language into Polish language. Although Polish government adopted several attempts to improve the situation of deaf in Poland, for centuries the deaf, not only in Poland but around the world, have experienced discrimination. They were second-class citizens, and discrimination against the deaf is audism. It's an audism, and shortly, audism is the belief that deaf people are less intelligent because they are deaf and dumb. They are unhappy because they are people with disability, and they can formulate it and thought. They can express themselves, but it's not true. The deaf have own language. There are some languages. With determination, the bilinguists that sign languages are natural languages, a gradual, slowly process of the recognition has begun, and the legal recognition takes place at several different levels and different intensity. I distinguish the universal level. The first universal act, international act, is the Convention on the Rights of Persons with Disability. According to Article 2 of the Convention, the term communication includes languages, text, display, braille, communication by touch, but language under the Convention means spoken language and sign language and other form of non-verbal communication. The sign language appears several times in convention, at that convention. For example, Article 9, accessibility, and Article 21, the freedom of speech and expression and access to information. Article 24, education. Article 40, participation in culture life. European Union law. There is no binding rule in European Union, unfortunately, but fortunately, European Parliament saw this problem, and European Parliament in 2016 adopted a resolution in order to emphasize the necessity to change something in the legal sphere about the sign language. Especially, what is important, states have to take measures to recognize and promote the linguistic identity of deaf communities. What's about the domestic level? The subject of my research is constitution, so first I focus my research on the constitution, and there are several countries in Europe, European Union especially, which introduce sign language into a constitution in different manner. But first was Austria, Finland, Portugal, Hungary, and the last is Slovenia. And I would like to refer several words about Slovenia example, because Slovenia changed constitution 2 years ago. In 2021, they changed the constitution in order to strengthen the right of people with deaf impairment. And in 2018, the government introduced the proposal to change the constitution. And the government justify the necessity to change constitution following arguments. First argument, deaf experience difficulties communication to their hearing impairment, then don't have the same opportunity to exercise in their human rights as other citizens, then they don't fully participate in society, and they face many barriers in access to education, civil rights, political rights, etc. The second argument was focused on, the government focused on Slovenian sign language, saying this is natural, it's native language of deaf Slovenian, and it's completely independent of Slovenian spoken, because the Slovenian spoken is a Slavic language, but the native language of deaf Slovenes, it ranks lower than spoken Slovenian. They are not at the same position, although the Slovenian Sign Language is a native language of deaf Slovene citizen. So the language should have the same position, of course, legally, although legally the same position. And the third argument was based on the necessity to development, standardization, and protection this language as a communication system for deaf Slovenian citizens. And what's important, although the Slovenian parliament was politically divided and they survived political crisis at the moment, they decided to unanimously adopt this amendment to the constitution. So the constitution amendment has the following word: the freedom to use and develop to Slovene sign language shall be guaranteed. Statutory levels. Most countries regulate this issue of sign language and language rights of deaf at the statutory level. The most far-reaching solutions were adopted in New Zealand and South Korea because they granted official status. So the sign language in New Zealand and New Zealand sign language and Korean sign language are official in that country. In this way, countries raised its legal position or their legal position by taking steps to equate sign language with spoken and written languages. At the opposite side are countries where where sign languages are not being legally recognized. Until recently, this group included Italy and Bulgaria, which were the last in European Union to regulate the presence of Italian sign language and Bulgarian sign language in public sphere. What happened in Poland? In 2011, we adopted a law on sign language and other means of communication, at the same time removing very slowly, really very slowly, barriers in various areas in Poland. But this situation doesn't suit the deaf society in Poland. And in Poland, attempts are being made to introduce the Polish sign language into the constitution. And the Association of Polish Institute of Deaf Rights, referring to the Hungarian example, has proposed a new paragraph to Article 27 that reads: Poland shall protect the Polish sign language as a part of Polish culture. Of course, there's no will, and there's no will. It's impossible. There's no way. It's not possible to change the constitution in Poland at the moment. It's not a good time, but we should thinking about the future. But the fact that the Polish constitution fails to refer to the language rights of deaf may not be interpreted as a denial of such rights. I believe that principle of human rights is a normative source of these natural rights of deaf. From the other side, the principle of human dignity is a source of positive obligation to state to respect the natural rights of deaf in Poland. Why we should protect sign languages? Or there are lots of dangers. There are lots of danger. They are in danger, this language, because we observe the problem with this transmission sign languages, and this language is undergoing slow destruction. First, it's a cochlear implant, and early surgical intervention in the form of cochlear implant allows children with profoundly hearing impairment to develop properly, but still there are some group deaf in each country. And the second, it's the problem with the deaf school, because the deaf school was boarding and the deaf school are being abolished, and deaf children are being included in so-called integration school. These factors interrupt transmission of sign languages, not only in Poland, in New Zealand, I read about it, New Zealand, in Australia and United States. Several conclusions very slowly, I try to be slowly, but shortly. Sign languages are natural languages of deaf. The right to sign language is a natural right of deaf. It derives from dignity. States are taking steps to legally recognize that right, confirming it at the constitutional and statutory level. And moreover, the international community also recognized the need for legal guarantees for the language rights of the deaf. For example, the Convention on the Rights of Persons with Disability. And the last, the Polish Constitution does not explicitly confirm the right to Polish sign language, but I believe the principle of human dignity is a source of such right. Thank you very much. Thank you.
Thank you very much. It is very innovative and gives a lot of ideas that we, maybe lawyers, think that we know about everything about the Constitution. But it looks like that there are still many things that could be, but not are. But let's hope that in future the Constitutional Court will maybe interpret some articles of the Constitution, and sign language will have the status that it's needed. So thank you, Dorota, very much. And this, your presentation is not only how to say academic work, but also the help for us, all of us, yes, to know better. Yes, about sign language, because we see it, sometimes we know a little bit, but we never think about the status, the constitutional, and know the status of the sign language. So thank you very much. So dear colleagues, now we are moving to the last presentation in our panel, and we ask Professor Eglė Bilevičiūtė, Mykolas Romeris University, problem aspects of quasi-court institutions in Lithuania. So, please, we hope, yes, to listen for interesting presentation.
Good day for everyone. I will try to be very short and skip some parts of presentation about the common things from the quasi-court institution, the origin of quasi-court institution. Of course, I think all of you know that it could be two types, in internal and external quasi-court institution, and I am going directly to Lithuania. We have such system in Lithuania. We have ombudsman type institutions. Also, it's quite usual for European Union, and not only for European Union. Some of our public administration bodies have such power. For example, tax office, center of register, national land service, and of course we have two main independent quasi-judicial bodies, Lithuanian Administrative Disputes Commission and Tax Disputes Commission. And I put here the fourth. Really now this commission also it is separate commission, but this commission is under the liquidation procedure, and from the new year it would be integrated in Lithuania Administrative Dispute Commission. Really, where I see the main development trend in Lithuania, development of this quasi-court institution, independent quasi-court institutions. And you could see here the we have in Lithuania Administrative Dispute Commission 26 members. Of course, administrative staff also every member has, in Vilnius, every member has assistant. In territorial bodies, not every, but also we have assistants, the same as judges. And you could see our workload of last year. In 2021, it was about 1,800 cases. So, and I think that we are working quite effective. I didn't mention that I am also not only professor of Mykolas Romeris University, but the vice chair of Lithuania Administrative Disputes Commission. So you can see the features about appellation of our decisions, really just year per year, but 11 maximum it was 13%. Such disputes went to the courts, but courts cancelled about from whole our decisions about 2% from total amount. Yes, workload not the same as in courts. In administrative courts, it's not so much. In administrative courts, we have much more. But these quasi-court institutions really help to the courts to hear and to examine the administrative disputes. Here I presented for comparison the Tax Disputes Commission, just 5 members in Vilnius, and you can see the workload of tax disputes on such stage. The problems, main problems of such our institutions, really we have very uneven distribution of workload between central unit, Vilnius, and territorial units. Lithuania Administrative Disputes Commission, 7 members in Vilnius, have half of these disputes, of whole amount of disputes, and territorial bodies another 50%, or sometimes less. For example, Panevėžys unit, last year we had about 150 disputes, 150 cases. So we also not the same as judges. We have unequal salaries here in center and in territorial units. Less power, it means that we couldn't decide also concerning the damages, the costs of the hearings, and the parties should go to the court just for such issues, and it's not convenient and comfortable. This institution both is optional and really our parliament for 4 years have the project partly that's partly solved this problem, but it doesn't move. And really, the discussion and the development of this commission starts also with idea of limited appellation in administrative courts, and the main trend and the idea is to give more powers to quasi-court institutions, more types of disputes, and in such a way to reduce the amount of cases, the workload of our administrative courts. Also, I have in presentation here the main features of the court institutions, not only quasi-court institutions, but court institutions settled by European Court of Justice, and whole of these characters, Lithuania Administrative Disputes Commission, also Tax Disputes Commission have, and Tax Disputes Commission, for example, twicely asked for decision from European Court of Justice, and it was accepted and examined. Okay, so about limited appeal, really we have big problem of administrative courts. First of all, difficult load to be only two-step system, and of course very low salaries. Judges, not of course only in administrative courts, but Lithuanian judges has very low salaries, and people, now even scientists, are not motivated to go to the position of a judge, even to the Supreme Court of Lithuania or Supreme Administrative Court. Really it's possible to implement it, the limited appeal in Supreme Administrative Court, and to give more powers to quasi-court institutions, and of course more cases. And the main advantages, very quick procedure in Lithuania Administrative Disputes Commission. The hearings, we have just one hearing, and after the month, really after 20 working days, the parties have the decision. Less formal, more flexible procedure without cost for applicant, and mandatory decision also is very important advantage. And disadvantages I mentioned already: limited competence, the institutional framework, for example, this part where the public administrative bodies also have the quasi-court power. It's really almost totally the same as administrative procedure in our public administration law. So sometimes, really not sometimes, but I can't see differences, because both procedures is the examination of a claim. So, as I mentioned, both quasi-court institution is optional. You can go directly to the court, of course, but for example, first level of administrative court, the case would be heard, examined around 1 year, and in Supreme Administrative Court 1.5 years till the 2 years. So, and possible solutions also I presented: to give more powers, to implement limited appellation, and maybe transform quasi-court institutions to the first level of administrative court, so we will have 3 levels, but it depends on the political decisions and so on. So thanks a lot. I try to be very quick.
Yes, thank you very much. You saved our time, and it is very, of course, important and very good. No, it's of course, a very big value to give such a very, how to say, no, not short, but very rich and composed, in a very well composed presentation. So thank you, Agle, very much. And of course, we have different discussions in Lithuania regarding quasi-judicial institutions, whether they really have to be mandatory. No, I think that they could be, but still there are a lot of discussions. But if we have them, maybe they have to work fully. And of course, there is another discussion regarding is this some kind of mediation? Or for mediation, we have to have something extra. So I think that everything is developing, and I think that understanding of the court, understanding of the judicial institution is also developing. A lot of different, because what is the court? It is to solve the dispute. So these disputes we can solve in different ways. So this is quasi-judicial way of solving by these institutions, but of course mediation now is competing probably also very much, so maybe in future we will have maybe some even different institutions just for some different, to solve different disputes. So dear colleagues, if there are any, but I'm asking if there are any urgent questions, so please raise them. If because otherwise speakers will go for the lunch. So if I do not see any hands raised, so probably maybe we will leave discussions to the very end of our conference. And now we have to have a little bit to make some kind of rearrangement, because to be back at well, now probably we have to be back at 1:45, something like that. And the lunch for our guests will be arranged, but Eva, maybe you will provide some more information. And I am finishing my job, so thank you very much for your patience, and thank you for your work.
O aš negaliu užtraukti. Savo persijungu. Čia mūsų nerodo dabar. Ar čia Dieve? O gal iš viso nebeleiskite tai YouTube. Čia visi per ilgai kalba? Tai duok po valandą žmonėm. Ai va, o kur čia man persikalba tą stopą? Vieną kampą.
Esta mano kompas neišeina į transliaciją. Kompa garsus neišeina. Dingo. Reikės iš naujo ištransliuoti.
as a pre-watch to understand the approach and philosophy of the course.
Good afternoon, everyone. If I could have your attention, please. I'd like to welcome all here today. Now, let's go down to our third panel of Polish-Lithuanian colloquia. Each presentation should be up to 10 minutes. And we have presentation by Professor Dr. Wojciech Guzewicz and Professor Dr. Wojciech Gawliczek, which is called Law of the Armed Conflict Seen from the E-Learning Perspective, Innovative Approach, Best Practices and Recommendations. We have this presentation recorded.
Distinguished chairpersons, distinguished colleagues, firstly, let me express that it is a real pleasure and honor to participate for the 5th time in this unique scientific event, gathering the researchers from Lithuania, Poland, and not only. The format of the colloquium differs, depending on situation. This year, it is possible to meet again in person and to interact directly, but not for me. Due to other obligations, I am not able to stay with you together and to enjoy this option. Maybe next year it will be possible for me to attend. This brings me to the presentation I am going to deliver using e-learning tools available. Acting also on behalf of Professor Wojciech Guzewicz, this year, I am going to speak about the interesting combination, merging the e-learning solutions with legal topics, namely with the law of the armed conflict or international humanitarian law. Since ELK campus branch of the University of Warmia and Mazury enjoys the situations of having e-platforms and e-products, it is possible to participate in the international course sharing process. We have courses in English, French, Arabic, Ukrainian, and Polish, focused on cybersecurity, counterterrorism, culture awareness, and gender topics. Also on digital skills, what is of special importance for the e-teachers, e-trainers, e-instructors. To familiarize you with the background of this presentation, let me inform that it was possible to receive from the Swiss Armed Forces 2 courses focusing on law of armed conflict, basic one and advanced one. It takes approximately 3 hours to complete them. Of special importance is the approach introduced, based on gamification principles. It takes to collect certain number of points as the result of the decision made in the concrete dynamic situations connected with the realm of the warfare and military operations. The product was created by the Swiss commercial company and is available in 4 languages: English, French, German, and Italian. Swiss Armed Forces paid the producer more than 100,000 euros. Now, let me invite you to watch and hear a few minutes recorded as a pre-watch to understand the approach and philosophy of the course.
For generations, we lived well in our town. But then, one day, war came to our country. First came the slogans. Then came the news reports. Then came the fear. Then the electricity went out. Then we ran out of oil and fuel. Then our water was cut off. Then our garbage started piling up. Then came the hunger. And then came destruction. War has come to our country.
Come on, this way.
Well, well, well. So you speak some English? All right, I'll ask you one more time. Name and rank. Sergeant, what does it say on his identity tags?
Got it. Schmid, Luca. 000 7395 186400.
Is this you? Your ambush didn't exactly go to plan, did it? Who gave you the order? Who's your chief? You won't answer. We'll get you to talk. Private Muller, tie the prisoner up in this position. Let him suffer a little bit, until he talks.
Lieutenant, can I please have a word?
What's the matter?
Correct. Prisoners of war only have to share their rank, name and date of birth and unit. However, you cannot coerce them to do so. It is absolutely prohibited to intentionally inflict severe physical or mental pain or suffering for purposes such as interrogation, coercion, intimidation, punishment, or for any reasons related to discrimination of any kind. The same applies to the deliberate use of sensory deprivation as a means of coercion, for instance by blindfolding a prisoner. You must remind your superiors of this prohibition, and if necessary, refuse to carry out contrary orders. If a superior or colleague of yours violates this rule, you must report the incident to the next higher superior.
Okay. Put him back in a normal position and tie his hands in front of his stomach. You're lucky I'm in such a good mood today. Don't let him sleep till he cooperates. No food or drink. We'll try talking to him again tomorrow evening.
Correct. It is absolutely prohibited to intentionally inflict severe physical or mental pain or suffering for purposes such as an interrogation, coercion, intimidation, punishment, or for any reasons related to discrimination of any kind. This also applies to non-violent methods that only have this effect if used for a long period or in combination with other factors. This is the absolute prohibition of torture or cruel, inhumane, or degrading treatment or punishment. You must remind your superiors of this prohibition, and if necessary, refuse to carry out orders that violate it. If a superior or colleague of yours violates this prohibition, you must report the incident to the next higher superior.
Take the prisoner away and put him in solitary until we interrogate him tomorrow evening. Leave his handcuffs on, so he won't get any ideas or trash the furniture in his cell.
Correct. Prisoners must be treated humanely under all circumstances. Short-term solitary confinement may be justified if it is absolutely necessary to keep prisoners from colluding. But restraining a prisoner inside his cell is unnecessary and excessive. In principle, this amounts to cruel, inhumane, or degrading treatment or punishment. Such abuse is prohibited regardless of its purpose. You must remind your superiors of this prohibition, and if necessary, refuse to carry out orders that violate it. If a superior or colleague of yours violates this prohibition, you must report the incident to the next higher superior.
Just take the prisoner away.
This prisoner has confessed, but as she's a civilian, we can't lock her up with the female soldiers. Take her with you and put her in the communal cell with the male civilians.
Correct. Except for families, male and female prisoners must always be held separately and supervised by guards of the same sex. If there are no collective cells for women, she must be held in a single cell.
No, men and women have to be kept separately. Put the woman in solitary confinement. By the way of conclusion, let me inform you that courses are available on the e-learning portal of the EU Campus branch and currently are being adapted into Polish and Ukrainian languages. Having said that, let me thank you for your attention, hoping to see you soon. Thank you very much.
Thank you, Professor Wojciech Guzewicz and Professor Wojciech Gawliczek, for your presentation. Very new generation, high-tech, impressive, illustrative. And the second item on the agenda is what if there is no local plan? Challenges of the local government itself in Lithuania and Poland. And this presentation is made and presented by Dr. Monika Zinevich, University of Warmia and Mazury in Olsztyn, and Kristina Mikalauskaitė-Šostakienė, Mykolas Romeris University, Lithuania.
Okay. So, we would like to extend a very warm welcome to you once again. Especially, we would like to thank for Professor Eva Devetnikovaita and Professor Dorota Lis-Staranowicz for your invitation to this conference, for your all energy, motivation, and warm words to our science interests. And we would like to perform you another part of spatial planning and development and territorial planning in Lithuania, because today, from the view on the side of institution administrative law, not only from the material administrative law.
Okay. 2018, Dr. Professor Monika and I, we met at an international conference. We were presented our topics related with territorial planning, and the discussion that was started that day, it becomes the basis of comparative study of Lithuanian and Polish practices related to territorial planning processes. And the research results, our research results were presented in various international conferences, regional, global conferences. And today we would like to very briefly, we have an order. Would like to present you the main topics. The role of local self-government institution in the territorial planning processes, territorial planning at the municipal level, what is it? So the other question is the main challenges, yes? The main challenges for local self-government institution in the processes of territorial planning and territorial development possibilities if there is no local plan.
And the first aspect of the role of local self-government in Poland, it's very important when we can say about independence of municipalities' bodies. And Polish legislator especially includes this independence in 3 acts. The first is Constitution, and in Article 16, Item 2 regulates that local government participates in the tasks of public authority. Moreover, the local government performs a significant part of the public tasks established in it under the laws on its own responsibility. The other act is the law of commune self-agreement that in Article 7, Item 1 indicates that communes' own tasks include the following issues, and between really a few issues there is also the spatial planning and development. And the third one that detailed these aspects is Act of Spatial Planning and Development, and it clearly refers that shaping and conducting spatial policy in the commune, including the adoption of the study, moreover the local plans, taking into account their own tasks. What is very important that municipalities' bodies is not competence in establishing law of internal sea, moreover territorial sea, and exclusive economic zone, and also closed terrain.
I won't be citate the laws because it is written, you can see it. I would like to resume that territorial planning is an independent function of municipalities. It is obviously that municipalities and we communities that can best know their needs. What do they need for the community, for the environment, and the laws, as you can see, establish not only the right for territorial planning, but also the obligation, the duty for municipalities to plan. Municipalities actually shall create and operate a planning system which consists of special planning, strategical planning, etc., etc. And comprehensive, well known as general plans, must be prepared for each municipality. And actually in Lithuania, each municipality has a comprehensive or general plan. Because earlier today, Professor Yeva already told about municipality bodies, council, mayoral, so I skip it.
Yes. Because we compared these all documents on all levels of our countries, in Poland, spatial planning documents, and Lithuania as a territorial planning documents during our conference in China.
Yes, we did.
And during this conference, we really compare all these our documents. So today, we would like talk and focus only on main aspects of municipalities' documents. And in Poland, we've got As you can see, at the first position, study of conditions and directions of spatial development. And what is the important information that this act is regulated all territorial municipalities. This act is not local law. And that is the most mistake of our legislator. Moreover, its only base for local plan is unfortunately not base for our decision of local condition and localization of public purpose. The second, our documents, is local spatial development plan. I called it, and all lawyers called it, simply local plan, and this is a local law. Moreover, this also included all regulated that are obtained in study, and this is also the base for building permission in Poland that is used during construction process. And the situation, what we would talk today later, that if there is no local plan, we've got decision of local condition, but I will tell about it later.
And in Lithuania, as it's shown, we can find at municipal level and local level 3 types of different documents. I would like to say that all of them are legally binding documents. They are like law acts. So if we can see different levels of territorial planning documents, I need to mention that each lower level of territorial planning must operate in compliance with the approved solution of documents, as you see, of higher level territorial planning documents and detail them. If we have situation that there is documents at the same level, territorial planning documents, they must be coordinated.
Challenges for the local self-government in process of territorial planning. So in Poland, these challenges are consist in both field of administrative law, because with institutional administrative law and material administrative law, especially in Poland, study concerns all territory of municipalities and it has to be changed into general plan. This general plan has to be a local law because 2 days we have this regulation. The most important is that general plan has to be base for local plan. That's why this regulation will solve the problems of self-government institution we've established by the spatial planning policy and spatial order. Moreover, after this time, municipalities' bodies could stop under-controlled investment process that are provided by dishonest developers. Today, they simply abuse that decision of local condition is not compatible with study, their own private interest during construction process. That is why we have in Poland also terrain without spatial order and without sustainable development. Now we are waiting for new reform that help our municipalities institution. Poland legislator included in the project of law about spatial planning and development, and the main aspects of this project is that study is changed into general plan. Moreover, municipalities are obliged to realize these tasks by January 2027, and the new decision after this process of local condition have a term of 5 years for the validity. But what we do with current decision? Simply, our legislator also indicate that they will expire 5 years after the reform comes into effect.
Okay. And the challenges in Lithuania, of course, Lithuania faces not much less problems in territorial planning like in Poland. It's and those challenges, they are impact and they it's like obstacle to reach sustainable development goals. And what the main challenges is, of course, limited resources, a lack of public participation, corruption, and you can see a picture. It's actually information that was given from Central Investigation Board of the Special Investigation Service, STT. And you can see that just in one municipality, in Vilnius municipality, there were more than 150 criminal offenses, bury gifts, trading to influence, etc., which is forbidden in territory planning processes, forbidden in public administration as well. So problems, we have a lot of problems. Actually, we have instruments, but the main factor is human factor, actually. It's the main factor.
And now the step that we try to answer the question, what if there is no local plan in our country? So, first of all, I would like to remind you that this is for municipality bodies in Poland, not efficient situation. This situation is caused that study of conditions is not base for decision of buildings conditions. The legislator in Poland has regulated this situation in Article 4, Item 2 of our Law of Spatial Planning and Development. And moreover, sometimes this decision is correct tools of spatial planning when it's used in a rational way. But also in current regulation, unfortunately, we also have this situation that private developers abuses. And they try this situation used to carry out their own private interests. The problem is concerned with premises of those both local conditions and decision of localization of public purpose, because they are different from all premises and the range of rules that is obtained by our studies condition. The problem is also that the decision is carried out under no term of apply.
In Lithuania, actually, I think we have a little bit better situation with right to build. I will call this way. Right to build when you have no local plan or detailed plan, because all the territory of Lithuania is planned already. So if we don't have a detailed plan or local plan, there is possibility on the basis of 20th article of Law of Territory Planning to build without planning. But it is a lot of conditions that should be identified that you could build. If you if you are in a different situation, so if you want to implement your right to build, you should to plan. You must plan.
And our conclusion for today, we have to really do a big revolution with the order and compatibility between our decision of local condition, building condition, and our study. That's why we have to take the experience from another country, for example, Lithuania, because you have the general plan, and the most important thing is that this is a local law. Our study is the same if we could look at this after the task, issue, and condition.
But it's recommendation.
But it is only recommendation, only spatial policy, not local law. And if there is no local plan, this general plan should be law for another document that we
could gather documents for construction process that are compatible between themselves. This solution are properly direction for independent competence of public purpose for the municipality bodies.
And actually, all the responsibility for sustainable development would generally fall on municipalities.
Thank you.
Thank you, Professors Monika Zinevich and Kristina Mikalauskaitė-Šostakienė, for your very relevant, very informative, down-to-earth presentation on spatial development planning, local spatial development planning. And next, let's move on to the next presentation about out-of-court consumer disputes, which will be presented by Dr. Ieva Navickaitė-Sakalauskienė, Mykolas Romeris University, Lithuania.
Good afternoon. Nice to meet you all here at Mykolas Romeris University. And my biggest pleasure, because I represent the Institute of European and International Law, and it is always great pleasure to be invited by the colleagues from the Public Law Institute. And I feel a little bit like not in the frame, but still I will do my best. And my message today is that today we talk about challenges. Today we talk about public law challenges, and my message today is that the gap between public and private law is getting smaller and smaller. That is the simple thing, but that simple thing very quickly turns into new challenges which we face in our legal practice. So my topic today is institutions dealing with out-of-court consumer disputes, and I raised the question, what could be done better? And I would like to focus on the one thing. I'm not going to talk about procedure, about all these procedural things that these institutions are doing. I will just fly through my slides and take one aspect, and that aspect is unfair consumer contract terms. Because in Lithuania we have 5 out-of-court consumer dispute institutions, and each of them, they have their particular field. For example, we have a separate one for electronic communication services. Then we have the Bank of Lithuania, which deals with financial services. Then we have a separate one for energy and drinking water supply management services, then for legal services, and finally we have State Consumer Rights Protection Authority, which covers all other consumer disputes. And talking about unfair consumer contract terms, we have a special directive on this. And as all we know, every time a consumer buys a product or service from a professional trader, he or she is entering into contract. And this contract may contain unfair terms which are prohibited by European Union law. And of course, in law, we have the list. What is that unfair contract term? We also have courts practice where not the terms from the list are also defined as unfair. And one of the recent examples, it was from Lithuanian Supreme Court, when Supreme Court applied to the European Court of Justice and asked for the preliminary ruling. And the question was concerning the lawyer's fees and the principle of an hourly rate. And what did the ECJ say? The ECJ said that a term in a contract for the provision of legal services concluded between a lawyer and a consumer, which sets the price on the basis of an hourly rate without including any further details, does not satisfy the requirement of being drafted in plain and intelligible language. That means that this term is potentially unfair. When you say only, for example, that you pay 100 euro for 1 hour, but there is no estimation that for this dispute we need like 5 hours, and that a consumer could have an idea in what sum they will end at the end of the case. So one of the examples, we also have the pending dispute at the ECJ also from Lithuania about loans in foreign currency. That is also a big deal, where consumers took the currencies in Swiss franc, and quite in a short time that Swiss franc rose a lot, and they had to pay very much more than at the time when they concluded the contract. So again, we have here the questions about unfair contract terms, and we expect ECJ to answer these questions. And the basic consequence when the court says that the particular contract term is unfair, that this term has no legal or binding force on consumers, and it is declared void ab initio or from the start. And the National Court is under the obligation to disapply that term. And that was the introduction into the topic, and now I come again to the subjects who are responsible for applying rules on unfair contract terms. So we have two types of the subjects, as I said before, national consumer associations and national courts, of course. And when we talk about national consumer associations, here I raised the question for the first time, what could be done better? Here, in spite of the fact that we have 5 consumer protection organizations, as I talked before, only one state consumer rights protection authority deals with unfair contract terms. That means that we have that horizontal approach, which in my opinion is not effective enough, because, for example, Lithuanian bank, who deals with financial services, would be really more capable to deal with unfair contract terms in credit sphere or in credit contracts with consumers. But still we don't have that, and all the load is on the state consumer rights protection authority. And this problem gets even worse because now we have the new regulation. We have in 2019 the new directive, which is called the Omnibus Directive, which brings new things to that unfair contract terms directive. And those new things, those new measures, are aimed at preventing traders to use unfair contract terms. And those measures are fines for traders. Before, we didn't have fines for traders. As we said, we had only unfair contract term, which is not alive anymore. We just put it out of the contract and it's dead, and that's all. Now we have fines for traders, and of course, member states have to implement the rules into their national legal systems. And what does the directive say? It says that administrative authorities or national courts could impose penalties when establishing the unfair character of contractual terms. And now we look at the transposition, how these norms were put into our legal system. First of all, we have the Civil Code, and the main provision which deals with the unfair terms in consumer contracts, and it's the usual provision which court uses when dealing with consumer contracts. And in this provision, we even don't have a link that have attention. When you deal with the unfair contract term, the particular rules on sanctions are in another act. So the Civil Code should have the complementing paragraph 12 or whatever, providing that the rules on penalties when establishing the unfair character of contractual terms are set by special laws for practitioners not to be lost in the system, which is not simple. And the main legal act transposing that omnibus directive and dealing with these sanctions is the law on consumer rights protection. And in this legal act, we see that State Consumer Rights Protection Authority, when it declares that a term or certain terms are unfair, it has the right to oblige the seller not to apply these terms when concluding new consumer contracts. So it has a right to oblige. We look further, and in case of the further application, the same State Consumer Rights Protection Authority may impose a fine on the trader. And also what we have the special ruling, government ruling, where those rules on fines are even more detailed, what is the amount of fine and all other things. So when transposing this directive, the new things are that State Consumer Rights Protection Authority, after declaring that certain term or terms of consumer contract are unfair, has the right to obligate the trader not to apply these terms, and in addition, for the further application of the terms which were declared as unfair, the authority has the right to impose a fine. So far, so good, but what happens? And the court has the same rights, and the court even has an obligation to declare the terms of consumer contracts as unfair. And I give you one example, a very pretty known everyday example from the life of the court, when the court, ex officio on its own motion, declares unfair the term of consumer credit agreement, requiring to pay the procedural interest of 15% as unfair, because in the law we have 5%. That procedural interest is, when you start the case till the end of the final decision is enforced, the amount you have to pay. So the court declares that as an unfair term. Of course, after that, it has no legal or binding force on the consumer, and this means that the claim for the award of procedural interest is rejected. And from the transposition from the law on consumer rights protection, I have no answer whether the court stating that that term is unfair has also a right to oblige a trader not to apply that term in the future, or no. Then also I have the other questions, whether sanctions, which I have talked before, can also imposed by the court or no? If no, so does the court have a duty somehow to notify Consumer Rights Protection Authority that, look, we have this unfair contract term, and you have a right to impose fines. Please do something that in future we don't have these disputes anymore. Because on that consumer credit we have almost every month, and not one and not two. So still, our law doesn't give the answer to these questions. And here I come to the conclusions that national legislator did not take the opportunity to bring more clarity when transposing that new omnibus directive. Rules on sanctions applied to traders for the repeated use of contractual terms that have been declared to be unfair. We have no clarity in this field. Then concentration of application of rules on unfair contract terms in hands of one institution is not effective enough. And the role of national courts when the trader continuously uses contractual terms which have been found already unfair is not clear. We don't know whether the court has the right to apply a fine in its toolbox. And then, if it doesn't have that tool, the cooperation mechanism between the courts and state consumer rights protection authority notifying about contractual terms which have been found to be unfair by the final court decision is not defined and is still unclear. And what we have in the result? In the result we have that the obligation to strike the right balance between the interests of traders and consumers is still transferred on national courts, and their workload is still big and big. So thank you for your attention. Only 1 minute, I was out of my frames.
I very thank you, Dr. Ieva Navickaitė-Sakalauskienė, for an explanatory and revealing, and by the way, very closely related to European Union administrative law, one of the areas of this law, presentation. And let's move on to the next presentation. And the fourth item on the agenda is employee data, retention periods, and the right to be forgotten. The situation in Lithuania by Professor Andrejus Novikovas, Mykolas Romeris University, Lithuania.
Good afternoon. First of all, I would like to thanks for opportunity to participate in this conference and present my report about employee data retention periods and the right to be forgotten. I try to disclose the situation in Lithuania. The general data protection regulation provides the basic principles of personal data protection and the rights of the data subject. Article 17 of the regulation enshrines the right to be forgotten, which allows the data subject to require the controller to erase his or her personal data in the event of a breakdown of the employment relationship. In the relationship between employers and employees, there are a lot of discussion, for example, how long the employer must store the employee's personal data. There is a lot of disputes concerning the terms and periods after which the data subject acquires the right to demand the controller to erase his data. The regulation does not provide the time limits for the storage of personal data. Such terms are established in the national law of EU countries. After the provision of regulation, GDPR, came into force, the national legal acts regulating personal data retention periods were not changed. The right to request the erasure of personal data occurs if there is at least one of the reasons listed in the Part 1 of Article 17 of regulation, and you can see above that list of reasons. Also, regulation provides that data can be processed, stored and deleted after a certain time. Paragraphs 39 of the GDPR preamble state that the personal data should be processed only when the purpose of personal data processing cannot reasonably be achieved by other means. To ensure that data is not kept for longer than necessary, the data controller should set deadlines for data deletion or period review. The case in which the right to be forgotten cannot be exercised are provided for the GDPR exactly in Part 3 of Article 17. As mentioned before, the right to be forgotten is not absolute. One of the conditions obliged the data controller not to erase data to comply with the legal obligation established by the law of the member state. The general obligation to keep documents comes from the Civil Code of the Republic of Lithuania. Laws and other legal acts also set specific storage terms for documents. For example, law on document and archives of the Republic of Lithuania, which manager is responsible for preserving the activity documents of a state or municipal institution or company, non-governmental organization, private legal entity for the necessary time. Also, the Code of Administrative Offences provides the liability for the offenses of document management violations. The main document regulate the document storage terms is the Index of General Document Storage Terms, approved by order of the Chief Archivist of Lithuania, sets the general main terms for the storage of personal data of employees. If the data storage terms are not officially established, the responsibility to set the data storage term must be head of institution and companies. It should be noted that after the entry into force of the regulation, the personal data storage terms established in the index were not changed. It is logical to assume that this term must be associated with terms already established in legal acts, for example, the statute of limitation, procedural terms, or other legal facts and circumstances. The general limitation period for claims according to the labor law of the Republic of Lithuania is 3 years. According to the Civil Code of the Republic of Lithuania, this period is 10 years. Therefore, the most important personal data storage term should be associated with these terms. Priority should be given to the term provided in the Civil Code because in labor disputes, the basis and the subjects of a dispute often coincide with the relationship regulated by civil law. In the following, I will provide information on the storage term of specific documents and will indicate why this term must be changed. Employees' contract had a 50 years retention period, which starts counting after the contracts expire. The term used to be associated with a person's lifespan and the employer's obligation to save the specific documents was based on the person's length of service, pensions, calculation, and etc. Currently, electronic reports of the labor relations in the SODRA database eliminate the validity of previously raised goals. The same should be mentioned about the terms of keeping a personal salary slips at the workplace. Keeping such personal data for 50 years not only increase the risk of unauthorized disclosure of personal data, but also creates a huge bureaucratic burden for employers who must retain these documents for a specific period. Considering the fact that the duration of personal data storage in certain cases could be related to the general limitation period of a claim, it can be assumed that a 10-year storage period would be sufficient for internal legal acts regarding employee, recruitment, dismissal, and etc. Another group of personal data is investigation documents of official and disciplinary violations, requires a clear validity of the storage duration and purpose. They must be kept for 5 years. The Labor Code stipulates the reasons when an employment contract may be terminated, for example, when an employer grossly violates his or her duty and during the last 12 months the employer commits a second similar violation of his or her duty. In such a case, to achieve the specific goals of providing the repeat branch of duty and the legal basis for dismissal, it would be sufficient to store these documents for 12 months. Considering the statute of limitation for labor disputes, the storage period for these documents could be extended up to 3 years. Another potential forgotten group of employers' personal data is performance evaluation documents. They are stored for 10 years, even if the information is not relevant to anyone after 1 year and does not create legal consequences. The optimal storage period for such a document would be 3 years. Another type of document is employees' vocation data. Part 5 of Article 127 of the Labor Code stipulate that the right to use all or part of the annual vacation is lost 3 years after the end of the calendar year in which the right to full annual leave was acquired, except in case where the employee could not actually use them. However, the index obliged employers to store a vacation data 10 years. It is suggested to set 3 years the storage period for document regarding annual paid educational and other leave, and 10 years the storage term can be provided only if the employee has unused vacation for more than 3 years. And the last one document is personal account cards are also expected to be stored in the index for a long time, 50 years. Now, when all financial documents are submitted to state institutions electronically in databases, when employees receive wage only to bank accounts, obliging the employer to additional storage employee accounts cards or notice for 50 years is an excessive requirement. That's all what I wanted to share with you. Thank you for attention.
Thank you, Professor Andrejus Novikovas, for an enlightening presentation. And now I would like to invite Associate Professor Tomas Žilinskas to present his presentation, Actual Legal Issues of Compulsory MTPL Insurance in Lithuania.
So, good afternoon to everyone who I didn't meet today. Today I'd like to present my topic, actual legal issues of compulsory MTPL insurance in Lithuania. So we have many issues, but I'll try to focus on some of them. First of all, I'd like to make a short intro about the relationship between compulsory third-party liability insurance and public law. So first of all, in case of compulsory insurance, the freedom of contract is limited because the obligation to conclude an insurance contract is established by law. Such a duty is established by law in order to protect not only the policyholders but also the legitimate interest of third parties who suffer damage as a result of the policyholders' actions, and this we can say that there is a specific public interest. The obligation to conclude an insurance contract can only be implemented through administrative measures. MTPL insurance is also object of European law. Motor insurance also has an impact on free movement of persons and vehicles. Member states shall refrain from making checks on insurance against civil liability in respect of vehicles normally based in the territory of another member state. I think our colleagues from Poland also took this opportunity to come from Poland to Lithuania with Polish insurance contract. They didn't have to conclude new insurance contract on the border of the country. So they came by bus, but bus driver didn't have to buy a new contract when they come to Lithuania. And European Union law directive establishes that each member state shall take appropriate measures to ensure that civil liability in respect of the use of vehicles normally based in its territory is covered by insurance. European Court of Justice also stated that the conclusion of a contract of insurance against civil liability relating to the use of motor vehicle is obligatory when the vehicle is still registered in member state. And one of the opinions of European General Advocates, Mendoza, is stated that the mere fact that insured vehicle could cause damage of any kind was a manifestation of member states' failure to perform its task of ensuring that every vehicle was insured. So how to understand such goal? All registered vehicles must be covered by compulsory MTPL insurance in European Union. Obligation to insure against such liability is to be interpreted as meaning that the conclusion of an insurance contract against civil liability in respect of the use of a motor vehicle is compulsory in circumstances where it is officially registered or used as a vehicle. Here is a case with Polish origin. and the opinion of Advocate General Bobek in European Court of Justice. The case was Powiat Ostrowski, sorry for my pronunciation, Polish, versus Obezpieczowy Fundusz Gwarancyjny. And General Advocate stated that very interesting thought that was if I built a Batmobile, you know, Batman has his own car. At home, at all technical characteristics of vehicle, and then instead of just admiring it in my living room, I drive it. The obligation to ensure it objectively from the first use of a vehicle, if I didn't not formally register it. So, what can be the conclusion of such statement is that Batman to European then come to European Union, will come to European Union. He will have to make his insurance contract with his Batmobile. What administrative measures are in Lithuania for lack of MTPL insurance? So there are administrative fines for drivers and vehicle owners, suspension of vehicle permit to participate in public traffic. Administrative measures for lack of MTPL insurance are such the amount of administrative fine does not depend on the category of vehicle. The administrative fine for drivers range from 50 to 100 euros. The administrative fine for owners of vehicles range from 60 to 120 euros. And the administrative fine for owners of vehicles, legal persons, range from 100 to 240 euros. Do the administrative measures in Lithuania work properly? Here is the statistics. So there are 2.17 million road vehicles in Lithuania registered. Of these, about 1.73 million are covered by compulsory insurance. So about 20 registered vehicles are not covered by compulsory insurance. This statistic is not so shocking if you count only uninsured vehicles that are used in traffic. So in 2021, there were 1.9% of such vehicles in Lithuania. Meanwhile, in Poland, only 0.3 or more than 6 times less than in Lithuania. So, and this slide is from last conference that we took place in Elk. And I asked question, does the insurance coverage always sufficient? And this slide, actually somebody saw it. So, and we didn't have the answer, and we tried to imagine such a situation, Bugatti Chiron Coupe, price $2.7 million, and how do you feel when you damage this car when you're going to the market and open the door? So we didn't have the answer. Now we have. After that, the European Court of Justice stated that after the conference, under the directive, the concept of use of vehicles covers a situation in which a passenger, not only driver, but also passenger of vehicle parked in a car park is opening the door of that vehicle, scrap it against and damage the vehicle parked next to it. So insurance, coverage exists. And now I'd like to talk about a little bit about new challenges which will come with a new directive of European Union that amended the previous directive, and this directive has to be implemented in national regulation on December 23rd, 2023 at the least. There are some new impacts in the new directive, for example, new definition of vehicle. So after the directive will take force in member states, the meaning of a vehicle will be any motor vehicle propelled exclusively by mechanical power on land but not running on rails, with a maximum design speed for more than 25 kilometers per hour, or a maximum net weight for more than 25 kilograms, and maximum design speed for more than 14 kilometers per hour. What type of new vehicle we will have? So a new type of vehicle that need to be insured will be electric scooter. So when you see such criteria, you can find that electric scooter will be a vehicle that will need to be covered by insurance. What's interesting is using this type of vehicle can also cause serious damage. And in 2019, 64 traffic accidents were recorded in which 67 people were injured. 2020 year, 99 traffic accidents were recorded in which 101 people were injured. 2 people died. And what's interesting, that in practically every such traffic accident, people are injured. And new challenges. So new challenges are scooters are not registered, so often its real owner is not even known. So real probability of increase of uninsured vehicles. The problem of controlling uninsured vehicles. And finally, how to determine the person responsible for a traffic accident when several people are driving or riding a scooter at the moment. So instead of the conclusion, I'll ask another question till the next conference. And the question is, who will be responsible in the event of traffic accident in this case? This photo was taken in Vilnius, I think, near Bernardinų Sodai, that place. And who will be responsible for the accident in that case? So that I don't know the answer yet either, but I can wait until the next conference and we'll have to discuss this slide. Thank you for your attention.
Thank you, Dr. Tomas Wišinskis, for such, I would say, joyful and authentic presentation. And also, I would like now to invite Dr. Leda Žilinskienė, and her presentation is Peculiarities of the Legal Regulation of Construction and Demolition Waste Management in Lithuania, Mykolas Romeris University, Lithuania.
Hello. Nice to meet you all. So I think I will shorten my presentation and draw some main aspects. So today I want to present analysis of construction and demolition waste management and how it is regulated in EU and Lithuania, what are main trends guiding regulation. And Okay, so composition. So construction and demolition waste is generated during the construction, renovation, or demolition of buildings, roads, bridges, and etc. And this C&D waste not only contains high proportions of inert materials, but also wood, metal, glass, and other hazardous substances such as treated wood, lead paint, asbestos from demolished old houses. So due to the variety of materials, it is important that the C&D waste be segregated at source with each stream managed as required. So as we see in the slides, C&D waste represents the largest proportion of total waste generated. It is 36%. And so we can skip to another slide, and we also can see that construction and demolition waste account for more than a third of all waste generated in European Union. And we need to acknowledge that proportion of construction and demolition waste makes a much smaller proportion in Lithuania. It is 10.9%, and general provision is that when waste management controls were first introduced in the 1970s, the illegal dumping of C&D waste was widespread, and in many developed countries it continues to be an ongoing problem. So what is the problem? That illegal dumps of construction waste acts like a magnets, and after that more waste comes, and it poses a serious pollution risk, and it is critically important to manage this waste sound. And as the bulk of C&D waste is inert in the 1970s and 1980s, this waste was typically landfilled, and over time C&D waste came to be diverted from landfilling to recycling, while more recently the focus has been on reuse and prevention. And illegal dumping of C&D waste is actual problem in Lithuania too. We are getting used to headlines like this. And general provision is that construction and demolition waste generation has increased considerably as a result of population growth and urbanization. And landfilling this amount of C&D waste has considerable environmental impact and take up a huge amount of space in limited landfills. So we have to think about alternatives of this to the waste landfill. So one of important concepts how to manage waste is circular economy, and it is considered as a practical implementation of waste hierarchy that guides activities toward prevention, reuse, and recycle within ambition target. And EU Action Plan for Circular Economy has established general measures to support this transition. And 4 amendments implementing circular economy were adopted in 2018, and one of them is Directive 2018-851, amending Waste Framework Directive, and it introduced a new definition, and one of the definition was construction and demolition waste, which means that waste generated by construction and demolition activities. And in the definition, municipal waste does not include construction and demolition waste. There are also some more provision in this directive concerning C&D waste. And in general, Waste Framework Directive sets the following objective. It is to promote selective demolition and prepare this waste for reuse, recycle, or other recovery, and also to reduce waste generation. And when speaking about Lithuania, the amendment to the Republic Lithuania law on waste management were adopted in 2021, and it introduced the definition of municipal waste, construction waste, and backfilling. And construction waste was clearly excluded from municipal waste, though the provision obliging the municipalities to ensure the construction waste is accepted from household without additional charge are also applied, as municipalities in general are responsible for municipal waste management. There is still a need to revise institutional responsibilities considering management of construction waste and clearly decide the financial issues of this of the management of this waste stream. And also it is considered the best interventions of the rules, so it is clearly indicate requirements for records on C&D waste on site, obligation to establish separate collection non-hazardous waste can be stored, and some more aspects. And we need I need to mention that we have a new national waste management plan which set out tasks for construction and demolition waste management. And yes, and in practice, study shows that construction sector need to improve and align in practice toward circular economy principle. However, in practice, potential for reducing construction and demolition waste is yet to be achieved. And so the main conclusions is that in Lithuania, we've made the necessary legislative changes concerning C&D waste, but there are still more problems to be solved, and also national waste management plans as tasks concerning this waste management, and some of the plans tasks are quite abstract and requires further examination, so it will take some time for changes in waste management sector. And illegal dumping is a serious problem which requires better supervision of construction sector and better institutional cooperation. So that's all.
Thank you, Dr. Rada Zilinskene, for an informative, explanatory, and revealing presentation. And it looks like we have covered the main topics, all topics, not of the third session or panel, but of the whole, our sixth Polish-Lithuanian colloquia. And I would like to invite Associate Professor Juozas Valčiukas, the head of the Institute of Public Law, Mykolas Romeris University, Lithuania, to conclude and close the conference.
Thank you so much, dear organizers, dear speakers, moderators, the audience who joined us here in the auditorium in person, and those who joined us virtually. I have a privilege to close this conference. Today we have a really interesting, engaging, and authentic conference. Presentations, as you listened, touched a huge variety of issues about the challenges in public law in Central and Eastern Europe. We looked through very different topics, from administrative liability, waste management, to the concept of war, data protection, or electoral law issues. I would like to emphasize that we had presentations from scholars representing 4 universities in Poland, Slovakia, and Lithuania. So, University of Warmia and Mazury in Olsztyn, Comenius University in Bratislava, the Cardinal Stefan Wišinskis University in Warsaw, and Mykolas Romeris University. On behalf of everyone here, dear audience, please let me take a quick few moments to say thanks. I want to say special thanks to the scientific committee of this event, first of all. Professor Jaroslav Dobkovsky, Dean of the Faculty of Law and Administration of Warmia and Mazury University. Professor Lira Jakulevičenė, Dean of the Law School at Mykolas Romeris University. Habilitate Dr. Dorota Listaranovic, head of the head of the Department of Constitutional Law at the Faculty of Law and Administration, University of Warmia and Mazury in Olsztyn. Habilitate Professor Dr. Julia Vaščenko at the Faculty of Law at Comenius University in Bratislava, at the Slovak Republic. Professor Dr. Zbigniew Witkowski, Dean of the Faculty of Law and Administration, Mykolas Copernicus University in Torun, Poland. Also, habilitate Dr. Joanna Juchniewicz, Vice Dean of the Faculty of Law and Administration, University of Warmia and Mazury in Olsztyn, again in Poland. I would also like to express our thanks to moderators of our conference. First of all, to the moderator of the first session, Professor Edita Sokolska. To the moderator of the second session, our Professor Toma Birmontene at Mykolas Romeris University. To Ieva Devetnikovaitė, Professor at Mykolas Romeris University. And dear colleagues, I must say sincerely, the biggest sincere thanks goes to Professor Dorota Listaranovic, as she is the main generator of the idea of this conference. So thank you all, and I would like to invite Dorota, dear Dorota, the soul of this event, to give the last closing word of this conference. Please, the stage is yours. Thank you so much.
True, but I will cry, I try not to cry. First of all, I'm very sad the 6th edition, the 6th colloquium is behind of us, because it's wonderful time. We spend wonderful time in wonderful society, because we are wonderful together. Together we're wonderful. And because tomorrow we have to come back to home, to our daily duties, to children, to kitchen and other duties. Not only scientific duties, but before us is the 7th colloquium. The 7th colloquium, that's why I am happy that we will meet next year in Olsztyn and invite you all to Olsztyn. I warmly invite our Lithuanian hosts, also our colleague from Comenius University, and special thanks. First, I would like to thank to the host, Dean, Professor Lira Jakulevičenė. Second, Jozas Valčukas, the head of the Institute of Public Law, Mykolas Romeris University, for your hospitality. Second, from the bottom of my heart, it's difficult to say me, I would like to thank to Professor Ieva Devetnikovaitė for everything, for our conference, for our book, for our following books, for taking care for us in Vilnius, in Lithuania. But I don't forget about a team or company, it's a Zieliński team. Leda and Thomas, because you are with us from the first colloquium. We met the first time in EUC, and you can count on your all. Thank you very much, and see next year in Olsztyn. Thank you.